Hey, chat. Sorry about that. We were running a little late tonight, and also I would need some time to put a thumbnail together, and that took a little longer than I anticipated. So I am so sorry about the wait. A couple minutes late, but hey, it happens. It happens. I've just shot my tongue off. All right. Potentially trans. Yeah, no, close. All right. Anyways, welcome, guys. My name is Sean, also known as Potentially Criminal. I am a defense attorney out in the Cleveland, and just an attorney in general in the Cleveland, Ohio area. And tonight we're going to be looking at the oral arguments for United States v. Skirmetti. Just before we get any too far into this, it's the United States versus the Attorney General for Tennessee. The Attorney General for Tennessee is Jonathan Skirmetti, so that's why it's titled that. And the issue is at this point, it is whether in Tennessee they passed Senate Bill 1. And Senate Bill 1 prohibits all medical treatments intended to allow a minor to identify with or live as a purported identity inconsistent with their natural born sex, or treat purported discomfort or distress from a discordance between the minor's sex and asserted identity. And the argument is whether or not that violates the Equal Protection Clause of the 14th Amendment. So that's ultimately where we're at with this. This is the 14th Amendment issue. It's about whether or not this violates the Equal Protection Clause. And it's about a bill that prohibits that kind of treatment for minors. And that's kind of where we are with this. Case of Bitcoin got to 100K. Whoo, child. That's nice. I'm the biggest procurer of bull peens in the state of Ohio. 2.0 is the biggest. God, my hair is long. It needs cut. Also, I probably need to. Well, I combed it this morning, but it gets all fucking out of whack now by the end of the day. So anyway, that is 2.0 is the bull peen procurer. That's hopefully not the kind of Destiny kind of oral. Yes. So we are going to go forward and do this. So let's get going. And when we get to it, guys, we're going to stop because there's like a special kind of like novelty argument that gets made. And, as much as, I will make fun of trans people, and I think ultimately at the end of the day, I think that they, suffer from some very severe mental health issues. And I wish them the best in resolving them, but I don't think indulging them ultimately gets them where they need to go. But, that's obviously they want to go do their thing. But there is a bit of this I don't like, because I feel like a person took an advantage, like they put a person out there and parade them out there and let them embarrass themselves. And I think that was wrong. I think that was wrong forever who it was. And regardless of who they are, it's bullshit the way that person got done dirty today. We're going to get to that. We'll get to that. You'll hear my thing. But here we go. So we are going to use C-SPAN because they show faces. The closed captioning is all jacked up, chat, so my apologies in advance. Maybe you can use closed captioning out there in Radioland and see if it works. So here we go. Let's get to it. This is United States versus Skirmetti, and we are in the Supreme Court of the United States, chat. Remember, these are oral arguments. There is no video, but there is audio, and we can thank COVID for that. So here we go, live audio. Hella says, should I do a stream on the Jaguar rebrand? Yeah, because it's fucking sad. It's so sad. And Blade is right at this point. Yes, we don't tell schizophrenics, yes, Frank, the toaster really is talking to you. We never do that. But anyways, here we go. Here we go. So this is it. And I've got the volume turned up all the way, chat, and I'm gonna actually, do I have the volume booster? Yes. Let me know if this helps, chat, 'cause I've got the volume booster thing going as well. So look, there we go. I'm almost up there with the Supreme Court. One day, chat, one day. So here we go.
General Prelogger.
Mr. Chief Justice, and may it please the court.
This case is about
Also, there's Kurt's crush. But yes, this is Elizabeth Priliger. She is a United States Solicitor General, so you hear her address her as General Priliger. I hate that they label her that, but yes, that's technically the term she's used. So here we go. She's arguing on behalf of the United States.
access to medications that have been safely prescribed for decades to treat many conditions, including gender dysphoria. But SB 1 singles out and bans one particular use. In Tennessee, these medications can't be prescribed to allow a minor to identify with or live as a gender inconsistent with the minor's sex. It doesn't matter what parents decide is best for their children. It doesn't matter what patients would choose for themselves. And it doesn't matter if doctors believe this treatment is essential for individual patients. SB 1 categorically bans treatment when, and only when, it's inconsistent with the patient's birth sex. Tennessee says that sweeping ban is justified to protect adolescent health. But the state mainly argues that it had no obligation to justify the law and that SB 1 should be upheld so long as it's not wholly irrational. That's wrong. SB 1 regulates by drawing sex-based lines and declares that those lines are designed to encourage minors to appreciate their sex. The law restricts medical care only when provided to induce physical effects inconsistent with birth sex. Someone assigned female at birth can't receive medication to live as a male, but someone assigned male can. If you change the individual's sex, it changes the result. That's a facial sex classification, full stop, and a law like that can't stand on bare rationality. To be clear, states have leeway to regulate gender-affirming care, but here Tennessee made no attempt to tailor its law to its stated health concerns. Rather than impose measured guardrails, SB 1 bans the care outright, no matter how critical it is for an individual patient. And that approach is a stark departure from the state's regulation of pediatric care in all other contexts. SB 1 leaves the same medications and many others entirely unrestricted when used for any other purpose, even when those uses present similar risks. The Sixth Circuit never considered whether Tennessee could justify that sex-based line. Because the Equal Protection Clause requires more, this court should remand so that SB 1 can be reviewed under the correct standard. I welcome the court's questions.
Much of the latter part of your opening statement suggests that it seemed to suggest that there's an outright ban on this treatment, but that's not the case. It's really for minors. So why isn't this simply a case of age classification when it comes to these treatments as opposed to a ban, as you suggested in your opening statement?
It's certainly true, Justice Thomas, that the statute classifies based on age, but it packages that age classification with a sex restriction and says that for all adolescents, you cannot take these medications if they're inconsistent with your sex. So I acknowledge that the state so far has not banned this care for adults, although I think that the arguments it's making that this isn't a sex-based line in the first place would equally apply in that context. But the court has likewise made clear that when you classify on the basis of multiple characteristics, you can't avoid heightened scrutiny just because you have a non-protected characteristic that accompanies the protected one. And if you look at it from the standpoint of the plaintiffs who are actually affected by this law, the reason I'm calling it a categorical ban is because the state has left no out for those patients to obtain these medications when there's a showing of individualized medical need. And that is, I think, a stark departure from how the state ordinarily handles issues related to measuring risks and benefits, even in the pediatric context.
Well, is there no difference if a girl takes testosterone or if a boy takes testosterone?
So the district court specifically considered this question in detail and found that with respect to the risks that the state had identified, it was not substantiated that there would be unique risks associated with the cross-sex use of the hormones.
Is there no physiological difference?
Certainly, I understand that there are biological differences between males and females, but when it came to the specific risk factors that the state was focused on, what the district court found is that many of those risk factors would exist regardless of the birth sex of who was taking those medications.
I'm more interested in whether or not there is a difference in testosterone and its reaction in a male as opposed to a female, and
So,
vice versa for estrogen?
so if you take hormones, they will prompt.
Uh-oh. Uh-oh. Uncle Clarence. Uncle Clarence, he's like, I see through your bullshit. He's like, I'm just asking questions. Don't worry, Clarence Thomas talks a lot this time. He talks a lot tonight.
The development of secondary sex characteristics in whether you're a male or a female. If you take testosterone, you might develop a deeper voice register. You might have facial hair growth. And in fact, that's one of the intended effects of these treatments, because that can be critical to helping manage gender dysphoria that transgender adolescents would otherwise experience. But I think when it comes to the question of whether that creates unique risks, the district court found that for the most part, the state had not substantiated those risks, and that it leaves regulation of medication unrestricted, even in contexts where these same medications or others would pose a comparable set of risks.
General, can I just...
Counsel.
Guys, anytime it's the United States in the caption, you're going to see Elizabeth Prelogar until Trump wins. So, like, let's say this is 2021. Anytime the United States is arguing a case in front of the Supreme Court, Elizabeth Prelogar is going to, I know Kurt's probably mad I'm butchering her name. Elizabeth Prelogar is gonna be the that's the perk of being Solicitor General. You get like in front of the Supreme Court like a million times. Like, it's actually pretty cool in that regard. It's like playing for the Yankees. You get to play Yankee Stadium all the time. So she's always gonna be doing this, chat. She doesn't just happen to be like the best. It's the Solicitor General's like perk of the office. You get to go argue.
So,
and also, you guys think this is bad. Remember, Trump's got that guy who's kind of got like the Robert Kennedy voice, and he's kind of like D. John Sauer. You guys hate listening to her. You were gonna hate listening to him. Just saying.
Rely very heavily in your briefing on cases like Morales-Santanas, which was about the distinctions between men and women when it came to adoption and things of that sort. Here, it seems to me that the medical issues are much more heavily involved than in many of the cases that you look to, including, I understand there's a dispute between both sides on how extensive any evolution or increase in uncertainty in Europe has been and elsewhere. And of course, we are not the best situated to address issues like that, unlike in, like Morales and Craig v. Bourne and some of the other ones, where it doesn't strike me that they're intensely affected by medical considerations. And if that's true, doesn't that make a stronger case for us to leave those determinations to the legislative bodies rather than try to determine them for ourselves?
So let me respond to that concern with a couple of different points, Mr. Chief Justice. I certainly take the point that you might think that states should have a lot of leeway to regulate when it comes to medical uncertainty, and we're not arguing otherwise. If the state is not restricting access to medications on the basis of a protected characteristic, that is only going to be rational basis review from the outset. And it's only in a circumstance where the state is saying your access to drugs depends on your birth sex or your sex generally, that the court would apply heightened scrutiny. But even at that stage, I don't think it's necessary for the court to step in and suggest that states have no ability to draw those kinds of lines. And I think this relates to my point in colloquy with Justice Thomas as well. We, of course, recognize that if there is a lot of medical uncertainty or differential risk, and if the state can actually come forward and show that it has an important reason to restrict access based on sex, that can be taken into account in heightened scrutiny, and it wouldn't provide a basis to displace the state legislatures altogether from weighing this evidence. But I think it would be a pretty remarkable thing for the court to say that just because we're in the space of medical regulation, you are not going to apply the traditional standards that ordinarily are applied when there's a sex classification.
Well, I guess I wouldn't say just in the area of medical regulation. It's more in the area of evolving standards and technical treatment issues and the effect of certainly prescribing particular medications. That seems to me to be very much in the area of medical nuances, unlike, Craig v. Bourne, different drinking ages, or Morales. Can men and women adopt children in the same way?
And I think the court could recognize that concern can be accommodated under intermediate scrutiny. It is not like strict scrutiny where states are automatically prohibited from drawing lines based on sex. They just have to come forward and demonstrate that they do have an important state interest. And I don't think it would be any different, Mr. Chief Justice, than if the state were to say, we think there's some concern about safety and efficacy for this drug with respect to women, so we're going to ban women from taking it. The court would recognize that's a facial sex classification, and then the role for the court is not to come in and entirely second guess the legislature, but you would ask questions like, well, is there evidence to suggest it's risky for women but not for men? And what does the state do when there's comparable risk in other contexts? Does it just ban medication outright, or are there less restrictive measures? And could the state have tailored its approach to the unique concerns and try to potentially screen for the people for whom this would be safe and effective while enacting a more tailored law to try to safeguard against that important state interest? So I don't think we're asking the court to break new ground in this case. And in fact, we don't even think the court needs to delve into the heightened scrutiny analysis itself here. We think it would be sufficient for the court to recognize that a law that on its face says you can't have medications inconsistent with sex is a sex classification. But then you could send this case back and have the Sixth Circuit do the heightened scrutiny analysis in the first instance.
General, can I ask you a question about the state of medical evidence at the present time? In your petition, you made a sweeping statement, which I will quote: overwhelming evidence establishes that the appropriate gender-affirming treatment with puberty blockers and hormones directly and substantially improves the physical, psychological well-being of transgender adolescents with gender dysphoria. That was in November 2023. Now, even before then, the Swedish National Board of Health and Welfare wrote the following: they currently assess, quote, that the risks of puberty blockers and gender-affirming treatment are likely to outweigh the expected benefits of these treatments, which is directly contrary to the sweeping statement in your petition. After the filing of your petition, of course, we saw the release of the Cass report in the United Kingdom, which found a complete lack of high-quality evidence showing that the benefits of the treatments in question here outweigh the risks. And so I wonder if you would like to stand by the statement that you made in your petition, or if you think it would now be appropriate to modify that and withdraw the statement that there is overwhelming evidence establishing that these treatments have benefits that greatly outweigh the risks and the dangers.
I, of course, acknowledge, Justice Alito, that there is a lot of debate happening here and abroad about the proper model of delivery of this care and exactly when adolescents should receive it and how to identify the adolescents for whom it would be helpful. But I stand by that there is a consensus that these treatments can be medically necessary for some adolescents, and that's true no matter what source you look at. You mentioned both the Cass report and Sweden,
well,
but neither of those
can
jurisdictions
be medically necessary for some minors, but for the general run of minors, do you dispute the proposition, in fact, that in almost all instances, the judgment at the present time of the health authorities in the United Kingdom and Sweden is that the risks and dangers greatly outweigh the benefits? Do you dispute that?
I do dispute that, because if you actually look at how those jurisdictions are addressing this issue, they have not outright banned this care. The Cass report says at multiple points that this care can be medically indicated for some transgender adolescents. And of course, it's true that they have called for a more individualized approach to these issues and have questioned whether it should be readily applied to all adolescents as a matter of course.
Is it not true that in England, I'm sorry to interrupt, but time is running out, that the National Health Service some months ago limited the prescription of puberty blockers to adolescent males who are over the age of 16 and are already on estrogen, but for those who are under the age of 16, it's allowed only for experimental purposes. Is that not true?
So the approach in the UK right now is to allow hormone therapy for anyone 16 and older. And with respect to puberty blockers, the UK has restricted new prescriptions outside of research settings. But the Cass,
I mean, I will give her credit. She is fighting back, but oh boy, oh boy, oh boy, oh boy.
implementation plan itself makes clear that if a medical team determines that these medications are necessary for a particular patient, they will be provided. And that is
And the restriction that I mentioned was imposed by the British government some months ago. It was reaffirmed by the current Labour government, was it not? It was upheld by the High Court of Justice as based on sufficient medical evidence. Isn't all of that true?
I believe that all of that's true. It's outside the record in this case. And so I haven't myself confirmed everything that you just cited, which wasn't before the district court in this case. But let me make a couple of additional points. To the extent that you think that this needs to be taken into account in the application of heightened scrutiny, there's a time and a place for that, and it's with record evidence on remand. We think the court here just needs to recognize the sex-based classification in this statute and send the case back. If the court wants to go ahead and look at what's happening in Europe, the UK has not categorically banned this care. Sweden, Finland, and Norway, the other jurisdictions that my friends point to, have not banned this care. And I think that's because of the recognition that this care can provide critical, sometimes life-saving benefits for individuals with severe gender dysphoria.
Thank you, counsel. Justice Thomas, anything further? Justice Alito?
In your opening brief, you did not mention any of these European developments. And in your reply brief, is it not true that you just relegated the Cass report to a footnote?
So, Justice Alito, with respect to the developments, there has been no change in the law that I'm aware of in Sweden, Finland, and Norway. Each of the medical authorities in those states has called for an individualized approach to care. They've said it shouldn't be routinely applied, but they have not changed their laws to do anything like what Tennessee is doing here, which is to categorically ban it no matter the need. With respect to the Cass report, that isn't in the record in this case, but we have discussed that report in our reply brief. And as I just noted, it likewise recognizes the need for this care in individual cases. The UK has not banned the care, and Hillary Cass is not calling for such a ban.
Your primary argument in your oral presentation this morning is based on Bostock-like reasoning. Is that not correct?
I think that's incorrect. Our primary argument is that this statute on its face says you can't have medications inconsistent with sex. And no matter what you think about transgender discrimination generally, that's a sex-based line. It's no different than saying you can't dress inconsistent with your sex. My friends concede on page 25 of their brief, that's obviously a facial sex classification, but our primary argument is SB1 is worded exactly the same way and it works exactly the same way.
Well, you have a Bostock-like argument, and you say that a girl who wants to live like a boy cannot be administered testosterone, but a boy who wants to live like a boy can be administered testosterone. So, and that's one of your major arguments. I take that to be a Bostock-like argument. So my question is, why should we look to Bostock here? Bostock involved the interpretation of particular language.
All right, chat. When they talk about Bostock, they're talking about this case, Bostock versus Clayton County. So some of you guys are saying Bostock. No, it's Bostock. You're having a Bostock-like claim, and the claim comes from the case of Bostock versus Clayton County. And this is an actual case where I saw a couple of you asking about this. So, and this is a case where it protects employees against discrimination because of sexual or gender identity. And this is from 2020. So this goes back. This is during the Trump presidency. But anyways, Gerald Bostock was fired from his county job after he expressed interest in a gay softball league at work. So that was the argument there, and that's what happened. And ultimately, it's an employer fires an individual based on their sexual orientation identity violates Title VII of the Civil Rights Act. And this came out of the 11th Circuit. Now, if you've never seen this, here is how it broke down. Gorsuch, and it's actually it's a pretty well-written opinion. Gorsuch writes it. He's joined by Roberts, and then it's funny who's not on the court anymore. Ginsburg, Breyer, Sotomayor, and Kagan. Alito, Thomas, and Kavanaugh joined him. If you throw on Amy Coney Barrett, I think it probably still is 6-3, and then you'd have Ketanji Brown Jackson on there too. So I think you'd have Barrett over here as well. I don't think it would change too much, but that's the case they're talking about. Now let's get back to this.
In a particular statute. And this is not a question of statutory interpretation. It's a question of the application of the Equal Protection Clause of the 14th Amendment, and the court has addressed the question of how an equal protection claim should be.
How is it a compliment if I'm a fat Icarus? Icarus didn't turn out so well. I'm just saying. Unless you're already fat Icarus, and then you just put my picture in. I'm not really sure. Like, as if that came afterwards, okay, cool. But if you're implying I'm a fat Icarus, that makes me nervous.
Analyzed when the law in question treats a medical condition or procedure differently based on a characteristic that is associated with just one sex. And that was Geduldig in 1974, reaffirmed in Dobbs in 2022. And neither Bostock nor Dobbs saw any connection between the Bostock reasoning and the Geduldig-Dobbs standard. Bostock did not mention Geduldig, and Dobbs did not mention Bostock. So why should we look to this Bostock-type reasoning here?
So with respect to how to identify a facial sex classification in the first place, I don't think there's any relevant difference between the court's approach in Bostock and what this court has long done under the Equal Protection Clause. In both contexts, the court has made clear that the right to equal treatment is an individual right. So you look at the particular person and see how the law affects them. And the court in both contexts has already made clear that sex just needs to be one but-for causal factor. It doesn't have to be the sole reason or the primary reason. So for purposes of identifying whether facial sex classification is happening at the outset, we think it's equal protection principles as much as Bostock that carries the day, although of course Bostock reinforces those principles. You asked why this case isn't controlled by Geduldig and Dobbs. The court's reasoning there was that when you have a statute that doesn't classify based on sex on its face at all, the fact that the medical condition might be something that only one sex can experience isn't a basis to necessarily say that's facial sex discrimination. But that doesn't apply in any relevant respect here. First, because here we have the facial sex classification. The statute says no medications that are inconsistent with your sex. And second, these aren't drugs that are limited to one sex or another. Both males and females alike for decades have been prescribed puberty blockers, hormones, testosterone, estrogen. They produce the same physical characteristics, as I was saying to Justice Thomas, no matter whether your birth sex is male or female. So this doesn't look anything like pregnancy, where the court found that the medical condition itself was expressly limited to one sex.
Well, I'm not sure that's anything more than a play on words. Suppose the statute said, let's just talk about.
Wow, he just said that doesn't
Suppose the statute
persuade him.
Said that puberty blockers may not be prescribed or administered to any minor for the purpose of preventing the onset of puberty prior to the time when puberty generally occurs. Okay, that statute makes no reference whatsoever to anybody's sex. It applies to all minors. Would you say the same thing about that?
So I'm sorry, if I'm understanding the hypothetical correctly, the statute says you can't take puberty blockers before the time when you would ordinarily have puberty, so it's ruling out precocious puberty?
You cannot, no, it doesn't rule out precocious puberty. It rules out the administration of a puberty blocker for the purpose of preventing puberty from occurring at the time when it generally does.
I see. So if you're hypothesizing a statute where, in essence, the legislature is trying to get at the idea of prohibiting access to these medications for gender dysphoria reasons or otherwise, then maybe you would apply an Arlington Heights type of analysis. But of course, that kind of law that you're hypothesizing would also prevent people from taking puberty blockers if they have cancer and want to preserve their fertility, because it would prevent them from undergoing puberty at the ordinary time. I think that's why the legislature hasn't tried to circumvent a facial sex classification by drafting a law like that. It would have many other applications that the state might not want to aim at. That's very different from a law like this, where the state was being clear, we only want to prevent the medications when it's inconsistent with sex. And we're doing that because we have an interest in having minors appreciate their sex and not be disdainful.
Well, let me ask one final question that addresses Geduldig and Dobbs. Let's take Geduldig first. One could make the same argument in Geduldig that you've made here. A man cannot, which concerned whether a pregnant woman was entitled to disability benefits for time missed at work when a man would be entitled to benefits for time missed at work. So in that situation, a man cannot work due to a medical condition that prevents him from working. He gets benefits. The woman cannot work due to a medical condition, pregnancy, that prevents her from working for a period of time. She doesn't get benefits. It's the same argument you're making here. Or we could do it in Dobbs. A man who has a medical condition that causes physical.
In chat, when they talk about Dobbs, they're talking about Dobbs versus Jackson Women's Health. That's the case that overturned Roe last year. So that's the case when they talk about Dobbs. That's what they're talking about.
And mental distress.
Sorry, I didn't bring that up earlier.
Limits his daily activities. Can get a corrective medical procedure. Let's say it's a hip replacement. But a woman who has a medical condition that produces similar consequences, namely pregnancy, cannot get an abortion. So you can make exactly the same argument that you make here under Geduldig and under Dobbs. And yet there was no equal protection problem in either of those cases.
And that's because the court said that there was no facial sex classification insofar as using pregnancy does not automatically mean that that's a proxy for sex. But here there's a facial sex classification. No one can take these medications if it would be inconsistent with their sex, and that's imposing on the face of the statute two parallel rules on classes of people according to their sex. All adolescent males who want to take these medications to feminize their bodies, and all adolescent females who want to take these medications for masculinizing purposes. That's a facial sex classification through and through,
Right.
And I don't think it's controlled by Dobbs or Geduldig.
Thank you, General.
Justice Sotomayor?
General, just to unpackage some of this argument, your point, I think, is very clear that Bostock is pertinent only to the extent that whether it's Title VII or the Equal Protection Clause, the first question is the legislature using sex as a classification, correct?
That's right. So our argument is that when you're looking for whether there's a facial sex classification under the Equal Protection Clause, it has always been the same but-for causation principles. And of course, we agree with the logic of Bostock, but we think that that logic carries over in this context where the court has already said it just needs to be one but-for cause. It doesn't need to be the only cause. And one way you look at that is seeing whether the application of the statute changes when you change the person's sex.
Now, Bostock is very different than this case because in Bostock, what we said is if you use sex at all, unless you have a statutory exemption, you can't do it, correct?
Exactly. And I think that's an important...
Under the Equal Protection Clause, we recognize there are inherent differences between the sexes.
And that can sometimes provide a legitimate basis for classification.
That's the point.
So you're exactly right. The standards for liability are different. Under Bostock and under Title VII, you can't use
with respect to the discussion about the European countries and the fact that they haven't limited these treatments altogether. The Cass report, as you point out, explicitly says that medical intervention might be necessary for some adolescents, correct?
That's right.
And that is recognized by all the European countries, correct?
Yes, I think it's reflected.
I'm surprised the Tavistock scandal out of Britain hasn't been brought up by any. The justices don't bring that up, and I'm very surprised that doesn't get any airtime here. But if you guys ever want to read about some Mengele shit, read about Tavistock, Tavis, Tavistock. It was fucking horrible what they did to kids.
In the laws of those countries, which have not outright banned the care.
Isn't the purpose of intermediate scrutiny to make sure that we guard against I'm not intending to insult, but we all have instinctual reactions, whether it's parents or doctors or legislatures, to things that are wrong or right. For decades, women.
Wait, hold on. Wait. Chat. Hold on. Time out. England is more than, Europe is more than France and England? No. What do you mean you guys all talk all funny over there. Are you telling me there's more countries in Europe? We didn't learn that. We didn't learn about none of that here in America. That's fake news. It's a lie. They're either baguettes or bongs. That's all they know. Germany and Italy, those aren't real places. Stop it. Stop it. I will ban you if you just start making stuff up. You just start making stuff up here, chat. We're not doing that. We are not doing that. Everything else is West Europe and East Europe. Yeah, I mean, like, there's like Europe Heights or like, yeah, East Europe. Isn't that the rest of it? I don't know. But yeah, we'll never be. Next year, going to be saying Belgium. Yeah, I know. I've heard of that place too. Isn't that next to Mordor? Tomorrow V. Anyways, thank you for being here. Tomorrow V. But trying to tell me there's more to Europe than France and England. Come on now. I was born at night, but not last night, sir. Liechtenstein. Why aren't we just making names up? Are we just making names up now? Sounds so funny. Estonia. Sounds like Elbonia. Sounds like made up to me. Latvia. Yeah, that just sounds like a place full of gypsies. Next you're gonna tell me Luxembourg is real as well, chat. Or Andorra or San Marino. Yeah, come on now. Oh. Hungary. Yeah, see? You're going to tell me that's a real place? I'm hungry. Okay? That's not the name of a place. That's how you feel. That's me every day. That's me all the time. I'm always hungry. Are you telling me I'm a country? I know, Baldonia, that's probably a real place in Europe. Monaco's a nice casino. I've heard Monte Carlo's kind of ghetto at times, so people have said that. So don't even get to the African names. Fucking Chad down there. I know. KJ says Dan Marino is a country. It's San Marino. Oh. Is Kino overrated? I mean, they're good. Are they as good? Are they the quality of their show is to surpass this show? No. They are very good at what they do. They are very good entertainers. So Sweet Bovine says Bohemia is a country. So is the Polish-Lithuanian Commonwealth, you heretic. Oh. My favorite place is Ham, Germany. Oh. Yeah, I know. That's right. Bohemia's a rhapsody. Is Gibraltar part of England? Yeah, it's part of the English protectorate. It's English soil. They consider it real. So, oh, sorry guys, that was just totally worth it. That was totally worth it. But yes, that is funny. They're basically just doing well, Sweden and England they transed a bunch of kids, and that's apparently all they're doing. Where's Prussia? Yes, it is always in our hearts. It is always in our hearts. It is always in our hearts, chat. So, yeah, the Dum Dum. It's where the armory is. They had the British had an armory there, an arsenal there. Mm-hmm. That's a shame. Says the Rock of Gibraltar is one of the coolest things I've ever seen in my life. I've heard it's pretty cool. I've heard it's pretty neat. So, anyways, we're gonna go, chat. We got to get going. Sorry, and yes, tomorrow, V. We are not all idiots. We know Europe's a real place. So, anyways, yeah, here we go.
We couldn't hold licenses as butchers or as lawyers because legislatures thought that that we weren't strong enough to pursue those occupations. And some people rightly believe that gender dysphoria
Bye, Todd.
may
We're going to get back to this,
may
though.
be
Hope
changed
you're
by
sticking around,
in
but
some
see ya.
children. But the evidence is very clear that there are some children who actually need this treatment, isn't there?
Yes, I think the evidence is uniform on that, whether you look at the standard of care, whether you look at the view of every major American medical association that has taken a position, many of whom are amici here. It's reflected in the clinical practice. The nation's leading children's hospitals for decades have been providing this care.
Some
Oh, I
children
understand your point. I
suffer
understand your point. We'll talk about
incredibly with
that.
gender dysphoria, don't they?
Yes, it's a very serious
They
medical
think
condition.
some attempt suicide.
Yes, the rates of suicide are striking,
Some
and it's a vulnerable population.
drug addiction is very high among some of these children because of their distress, correct?
It is a serious condition,
One of
yes.
the petitioners in this case described throwing up every day, going almost mute because of because of their inability to speak in a voice that they could live with. These are physically challenging situations as well, too, correct?
Yes, that's correct.
And isn't the purpose of intermediate scrutiny, the level of scrutiny that we apply, necessary to ensure that whether it's legislatures or this court, that we don't make those personal judgments, but that we subject the judgments about these issues to a heightened review to ensure that those children who are going to suffer all of these consequences will be made to do so only when it's compellingly necessary?
Yes, in a
Oh,
circumstance
it's
where the
all
state has an
necessary?
important
I don't
interest.
know
And we
about that.
don't think that that means the states are entirely barred from regulating in this space. Obviously, they are grappling with these issues in a variety of contexts. But you're right to say that when the state is using sex-based line drawing, a court needs to look at that. And the problem with Tennessee's law here is not that it's just a little bit over-inclusive or a little bit under-inclusive, but that it's a sweeping categorical ban where the legislature didn't even take into account the significant health benefits that can come from providing gender-affirming care, including reduced suicidal ideation and suicide attempts, and where the state leaves unregulated entirely access to these treatments in all other pediatric contexts where there's a similar risk-benefit trade-off. And for the families affected by this, Justice Sotomayor, these are difficult decisions. Obviously, anytime you're thinking about a medical intervention, you need to weigh risks and benefits. But the state has come in here, and in a sharp departure from how it normally addresses this issue, it has completely decided to override the views of the parents, the patients, the doctors who are grappling with these decisions and trying to make those trade-offs.
Thank you.
Justice Kagan?
General, I wanted to get your thoughts first on why one should think of this as primarily a sex-based classification, because there's another way of looking at a law like this, maybe a more obvious way, which is that it's a classification based on transgender status. In other words, there are trans young people on one side of the line and cis young people on the other side of the line, both male and female on both sides of the line. And why what is really going on here, I understand the formal ways in which this is a sex-based classification, but I'm wondering whether that's not a little bit formal. And what's really going on here is a discrimination against, a disregard for young people who are trans, and why we shouldn't think of the law in that way.
I think you can conceive of the law in that way, and we certainly do think that this law discriminates on the basis of transgender status, and that likewise should trigger heightened scrutiny, both because that's inherently a sex-based classification and because we think transgender status discrimination warrants heightened scrutiny in its own right. But I don't think it's unduly formal to look at this as a sex classification, and the reason for that is because of the first operative provision of SB 1, which says you can't have these medications to live or identify in a manner inconsistent with your sex. That is quintessentially imposing sex-based rules and expectations on adolescents in the state. And it's true, it arises in the context of medical care for transgender youth. But here we think it's a very straightforward path for the court to look at that and say, well, in any other context, when you say you can't do something inconsistent with a protected characteristic, that's obviously classifying people on the basis of that characteristic. And here it wasn't accidental or incidental. This is threaded throughout the statutory scheme because the legislature was quite upfront that part of the interest here is in ensuring that minors appreciate their sex and not become disdainful of their sex, or as Judge White put it in dissent below, that they look and live like boys and girls. And I think that adds on an additional layer of sex classification here insofar as it shows that part of what the state was attempting to do is ensure that adolescents conform their bodies to the state's physical expectations of how males and females should appear. It's not at all surprising to think of that as a sex classification.
So is what you're saying is that the two are just embedded in each other, or is what you're saying that sex stereotyping is built into our understandings of trans and cis classifications? Or again, is that this more sort of logical analysis that might be found in an opinion like Bostock? And maybe those are not exclusive, but what's your sense of that?
So I think those aren't exclusive. I think they're reinforcing here. And I guess what I would say is I think this is an even easier sex classification than maybe the one the court confronted in Bostock or the one the court would confront if the statute simply
this is
discriminated on the
easy?
basis of transgender status, because here the legislature actually put the sex classification into the face of the law.
I don't know how this is a bunch of kids wanting to get trans versus a gay guy wanting to play softball. I don't know how this is going to be easier, but let's hear this. Let's hear this.
So I think those aren't exclusive. I think they're reinforcing here. And I guess what I would say is I think this is an even easier sex classification than maybe the one the court confronted in Bostock or the one the court would confront if the statute simply discriminated on the basis of transgender status, because here the legislature actually put the sex classification into the face of the law and made the first order restriction here one that prohibits inconsistency with sex. And I just go back to the kinds of examples we give about dressing inconsistent with sex or pursuing a profession inconsistent with sex. I think the court's recognition that that is a sex classification is obviously right, but it also can build in a layer of conformance with sex stereotypes that might be underlying those laws and that we think equally underlie this one.
So let me flip now to what it means to do heightened scrutiny in this area, because as you point out, this law, and I think almost all of the similar, or maybe all of the similar laws that have been passed like this, allow this exact same kind of treatment for the opposite purpose, if you will. For a person born male who wants to get to puberty already,
Right.
And you say that that's a kind of under-inclusion problem, and it strikes me that on formal equal protection analysis, it is, unless the state can come forward with some piece of medical evidence that says that the risks are greater in the one area than in the other area, which you say Tennessee has not done. I guess what I'm asking is, isn't the structure of these laws going to mean that all of them are going to have to be struck down once you get to heightened scrutiny? Because you seem to want to say, no, you can do heightened scrutiny, but you can also make certain deferential moves towards the legislature. And I guess I'm pressing you on whether that's really true.
So I think it is true. To be sure, we think that a categorical ban like this one is severely under-inclusive and also severely over-inclusive, which is an important ingredient here, and so should be invalidated. And if other states likewise have this kind of sweeping ban, then they would fail under heightened scrutiny. But I don't think that means that heightened scrutiny ties the hands of the states in this regard. One of the problems with the state's approach here is that although it has targeted this gender-affirming care for disparate treatment on the basis of sex, as we say, it has left these exact same medications entirely unregulated for all other purposes, and also turned its back on how it handles the risk-benefit calculus with respect to all other pediatric treatments. But we do think there is a real space for states to regulate here, and I point to the example of West Virginia. West Virginia was thinking about a total ban like this one on care for minors, but then the Senate Majority Leader in West Virginia, who's a doctor, looked at the underlying studies that demonstrate sharply reduced associations with suicidal ideation and suicide attempts, and the West Virginia legislature changed course and imposed a set of guardrails that are far more precisely tailored to concerns surrounding the delivery of this care. West Virginia requires that 2 different doctors diagnose the gender dysphoria and find that it's severe and that the treatment is medically necessary to guard against the risk of self-harm. The West Virginia law also requires mental health screening to try to rule out confounding diagnoses. It requires the parents to agree and the primary care physician to agree. And I think a law like that is going to fare much better under heightened scrutiny, precisely because it would be tailored to the precise interests and not serve a more sweeping interest like the one asserted here in having minors appreciate their sex.
Thank you, General.
Justice Gorsuch? Justice Kavanaugh?
First, want to ask about our role here and pick up on the Chief Justice's questions at the beginning. Who decides? You've put forth forceful policy arguments to allow these medical treatments, and Justice Sotomayor's questions elaborated on that. But the 20-plus states on the other side put forth very forceful arguments against allowing these medical treatments for minors. So it seems to me that we look to the Constitution, and the Constitution doesn't take sides on how to resolve that medical and policy debate. The Constitution's neutral on the question. At least that's one way to look at it. I want to get your reaction to that. If the Constitution doesn't take sides, if there's strong, forceful, scientific policy arguments on both sides in a situation like this, why isn't it best to leave it to the democratic process?
Well, I do think that the Constitution takes a position that individuals are entitled to equal protection of the law. And I totally understand the force of your intuition that states need space to regulate and to try to take into account concerns like adolescent health. We're not denying that that's an important interest here. But when you look at how this law actually operates, what it is doing is denying individual plaintiffs the ability to access medications on the basis of their sex. And that doesn't mean that the states are disabled from taking into account the actual biological differences between males and females, but that has to be channeled to the heightened scrutiny stage. And I think that there would be a real danger in this court saying, looking ahead essentially and saying, we think there might be benign justifications here, or we think that states should have some flexibility in this regard to overlook the facial sex classification in the statute. If you are concerned, Justice Kavanaugh, about moving too fast in this space and maybe restricting the ability of states to take a close look at these issues, I think the court could write a very narrow opinion in this case, and the court could say simply that when you prohibit conduct that's inconsistent with sex, that is a sex-based line, so you do have to apply heightened scrutiny. But the court has made clear that that's an intermediate standard, and if the state can come forward with an important interest and substantiate that it needed to draw those sex-based lines to substantially serve the interest, that's going to be okay.
Keep going, sorry.
And the final point is, and you can send it back and let the Sixth Circuit grapple with this in the first instance.
On the sex discrimination point, I guess picking up on Justice Kagan's questions, the way you would think about this is, I guess, it prohibits.
Yeah, this is extreme, that's extremely broad. So, yeah, it's insane to hear how they're going, guys, but it is what they get to make the argument for.
All boys and girls from transitioning using certain medical treatments, and it doesn't say only boys can do so or only girls can do so.
Well, I think the problem with trying to put that transitioning label on it as a basis to avoid the sex classification is that transition itself is inherently tied to sex. In other words, the prohibited purpose here are those treatments that would allow a minor to live and identify inconsistent with sex, and the statute would permit anyone to have those treatments for the non-prohibited purpose, which again is when it's consistent with sex. The court has said many times that labels don't control in this space, and I think when you have that kind of purpose that's expressly defined using sex-based line drawing, you have to recognize that for what it is.
And no matter how you articulate the standard, whether it's rational basis or intermediate scrutiny, it'll come down to whether the state, and I think you said this, has sufficient justification for limiting these treatments for minors. And the state says its justification here is health and safety for minors. You say there are benefits from allowing these treatments, but there are also harms, right, from allowing these treatments. At least the state says so, including lost fertility, the physical and psychological effects on those who later change their mind and want to detransition, which I don't think we can ignore. We can't ignore what you're talking about and what Justice Sotomayor raised. I agree with that, but you can't ignore, I think, the risks on the other side of the balance. So even if it is intermediate scrutiny or rational basis, those justifications for the state, how do we as a court choose which set of risks is more serious in deciding whether to constitutionalize this whole area?
So let me react to a couple of different points you brought up. First of all, I do think that the standard of review very much matters. And the court has made clear that rational basis is an entirely forgiving standard. It applies to mundane economic regulation where there's no reason for courts to take a closer look. So I think the court should hold the line that anytime the state classifies based on sex, you do need to take a look at that. But I totally take the point that, of course, when a state is coming forward with an important interest like protecting adolescent health, that may well justify the lines the state has drawn. And it's not about asking courts to step in and make a first order determination about how to weigh risks and benefits. But I do think that the state is under a basic obligation to first substantiate its concern. And here there were extensive factual findings by the district court that many of the risks that the state was asserting are not uniquely tied to gender affirming care at all. And also to take into account the harms that would come from categorically banning access to medications on the basis of drugs, including the benefits that I was discussing with Justice Sotomayor. You mentioned fertility and regret, and I'd like to take both of those concerns head on. I do want to acknowledge that there is evidence to suggest that gender affirming care with respect to hormones can have some impacts on fertility. Critically, puberty blockers have no effect in and of themselves on fertility. So I don't think that concern can justify the ban on puberty blockers, which is just pressing pause on someone's endogenous puberty to give them more time to understand their identity. With respect to hormone use, there are some effects on fertility, but the court found that many individuals who are transgender remain fertile after taking these medications. They can conceive biological children. There are fertility preservation measures that they can undertake, and that they have to be counseled on those risks. And as I said before, I can understand that that could be a hard trade-off, but it's not unique to this care. There are other treatments for adolescents that likewise affect fertility, including some of those that SB1 expressly permits, like on intersex individuals who often have surgeries as infants that might permanently affect their fertility. I would also say that if you are concerned about fertility, there are measures the state could undertake, like requiring warnings, more informed counseling, trying to ensure that there's informed consent in this area. You also mentioned the possibility of regret. The record evidence demonstrates that the rates of regret are very low because for the population that has access to this treatment, so these are adolescents who have marked and sustained gender dysphoria that has worsened with the onset of puberty, they are very likely to persist in their gender identity. But if you're thinking about this from the standpoint of there's no harm in just making them wait until they're adults, I think you have to recognize that the effect of denying this care is to produce irreversible physical effects that are consistent with their birth sex, because they have to go through puberty before they turn 18. So essentially what this law is doing is saying we're going to make all adolescents in the state develop the physical secondary sex characteristics consistent with their gender or with their sex assigned at birth, even though that might significantly worsen gender dysphoria, increase the risk of suicide, and I think critically make it much harder to live and be accepted in their gender identity as an adult. Because if you're requiring someone to undergo a male puberty and they develop an Adam's apple, that's going to be hard to reverse, and they're more likely to be identified as transgender and subject to discrimination and harassment as adults. So I think the relevant question is, you have this population of adolescents, and there are documented very essential benefits for a large number of them, and maybe a small number that will regret this care, just like with any other medical care. But for the state to come in and just say across the board, you can't have the medication because of your birth sex, we don't think that's a tailored law.
You acknowledge there is some group, though, who later changes their mind and wants to detransition. That doesn't defeat your case. I just want to make sure you acknowledge there is, as a factual matter, some group of people.
Yes, we're certainly not denying that some people might detransition or regret this care, but all of the available evidence shows that it's a very small number.
Then to pick up on the Chief Justice and Justice Alito's questions, it's obviously evolving debate. I mean, just in the last couple of years in Europe, big changes in terms of how they're thinking about it and how they're thinking about these risks and benefits that you and I have just been talking about and you've been elaborating. If it's evolving like that and changing, and England's pulling back and Sweden's pulling back, it strikes me as, pretty heavy yellow light, if not red light, for this court to come in, the 9 of us, and to constitutionalize the whole area when the rest of the world, or at least the countries that have been at the forefront of this, are pumping the brakes on this kind of treatment because of concerns about the risks.
We certainly are not asking the court to set forth some bright line constitutional rules in this space that is going to really take further debate and evaluation of regulatory options away from states. We think, as I mentioned, that the court really only needs to decide the first order question here of whether this law classifies based on sex. I think that's entirely distinct from some of the concerns you've identified about what justifications the state has.
Do you think that West Virginia law you mentioned is constitutional?
I think it would likely satisfy heightened scrutiny. It hasn't been subject to adversarial testing because I don't think anyone has sued to challenge it. So I haven't looked at the record that West Virginia would build, but I do think that there is room here for states to enact tailored measures to try to guard against the kind of risks that you're concerned about and that the state has identified. And
last topic on the heightened review, and you say all we need to do is do heightened review, and that's kind of a minimal step. I mean, I'm not sure really that the follow-on effects of that could be pretty significant. I think Justice Kagan alluded to that in her question, or at least raised that as a question. And want to ask in particular about one thing. If you prevail here on the standard of review, what would that mean for women's and girls' sports in particular? Would transgender athletes have a constitutional right, as you see it, to play in women's and girls' sports, basketball, swimming, volleyball, track, et cetera, notwithstanding the competitive fairness and safety issues that have been vocally raised by some female athletes seen in the amicus brief of the many women athletes in this case? So can you explain how intermediate scrutiny would apply to women's sports?
Yes, and just as a threshold clarifying point, I want to be clear that when it comes to access to sex-separated spaces like sports and bathrooms, courts already recognize that those are facial sex classifications that trigger heightened scrutiny. So it's actually not the question teed up here about how to classify the law in the first place or how to identify whether it's a sex classification. Instead, that's taken as given in that litigation, and the entire focal point of the disputes in those cases has been, well, does the state have an important governmental interest, and does it need to draw the lines to exclude transgender people?
Right, but how would intermediate scrutiny, which we may not, if we went to intermediate scrutiny, there's a possibility we would apply it here. How would it apply to, in your view, and maybe you don't have fully formed views, which would be fine, but how do you think it would apply to sports?
So courts have split on that issue, and I hesitate to try in a vacuum without an actual factual record to try to opine on the state's justification and whether it will satisfy that standard. It's obviously a different set of governmental interests that are being asserted there, and those would have to be analyzed in their own right. But I think that this court, if it wants to preserve space to make clear that nothing here should be understood to affect the separate questions that are arising there, the court could very well do so, and we would have no objection to explicit language saying this decision does not in any way or should not be understood to affect the separate state interests there that have to be evaluated on their own terms.
Okay, but looking ahead, do you think it's logically possible as a matter of constitutional decision-making to say that laws like the ones that one at issue here do not satisfy intermediate scrutiny, but laws that restrict women's and girls' sports in a way that transgender athletes cannot participate would satisfy intermediate scrutiny? Is that logically possible?
Oh, yes, definitely. So we do think intermediate scrutiny applies in both contexts, but there are a different set of state interests at play. And I think one readily apparent difference is that in the context of sports, there are arguments made that affects the rights of cisgender women, and that the ability to allow transgender women to compete on those teams is going to be other regarding in the sense of having those external impacts.
No.
There's nothing like this here. allowing transgender individuals who have carefully thought about this and consulted with their parents and their medical team to access these medications that have health benefits recognized here and abroad in no way affects the rights of other people. And so I think the court could well understand the statute here to fail intermediate scrutiny, even if it would survive there.
Thank you.
Justice Barrett?
Morning, General. I want to pick up on one of Justice Kavanaugh's early questions. You know, he pointed out that the burdens of the law fall equally on boys and girls because neither can transition. And you responded that it's kind of the sex classification or the expectations that one will conform to one's, biological or gender assigned at birth. Why isn't that more of an Arlington Heights argument about intentional discrimination than if what you're really saying or what the legislature is really saying is the burden of this is going to be equally applicable. Neither boys nor girls can have access to these drugs. But the reason why is because we want girls to be girls and boys to be boys, at least until they're old enough to decide otherwise.
So I think it would be wrong to overlook the fact that even separate and apart from any interest in conformity here or sex stereotyping, this is a law on its face that does not subject boys and girls to equal treatment. And you can see that if you look at how the law applies to some of the individual plaintiffs. Take Ryan Rowe, who is one of the individual plaintiffs here. He wants to take testosterone in order to live and identify as a boy, and he's prohibited by SB 1 from doing so because his birth sex was female. But if you change Ryan's birth sex and suppose he was assigned male at birth, then SB 1's restriction lifts. So he is not being treated the same as a boy, who was assigned male at birth. And I think that is the kind of quintessential test the court has applied for purposes of identifying when there's a sex classification.
So what would your argument be if a new drug is developed within, say, 2 or 3 years that just the only purpose of the drug, there's no precocious puberty purpose or anything like that. The only reason to give this drug is it targets minors who have gender dysphoria particularly. And a state passes a law, the FDA approves it, so it's available in some states, but a state passes a law saying no one has access to it. So now you don't have that whole thing falls out.
Yeah. So that would not be a facial sex classification. And there, I do think that you would have to apply an Arlington Heights type of analysis to see whether the context and history demonstrate that actually the state was intending to treat people differently based on their sex. But I think that would function very differently from
Why
SB 1.
don't you have an Arlington Heights argument here too? Because I take it one thing you think would be wrong with that law is the stereotyping function.
Well, I think that Arlington Heights doesn't seem like the natural doctrinal home for a law like SB 1 that says on its face you can't act inconsistent with sex. And I take your point about that's applying some equal rules to boys and girls, but that's true anytime you have a law that says you can't act inconsistent with a characteristic. That means that there's going to be a restriction on males and a restriction on females. It's true of any other factor too, inconsistent with race, inconsistent with religion. You might say, well, that's not just singling out one religion or one race or one sex for disparate treatment, but I think it actually increases the number of classifications when you're applying parallel restrictive rules on the basis of a protected characteristic across the board.
So let me return to Justice Kagan's questions. She asked you whether really the more natural way to think about this is that it is discriminating on the basis of transgender status rather than, I feel like trying to make the Bostock-like argument, holding all things equal, or that you have to do this by reference to, biological sex, feels like an odd way to solve the problem. And kind of that hypothetical I gave you about the drug that just has the transitioning purpose. So if we just head on confront the question which you raise in the second part of your brief about whether transgender status should be a suspect class, one question I have is, at least as far as I can think of, we don't have a history of de jure, or that I know of. We don't have a history
I understand
of
the point.
discrimination against transgender people, right? You point out in your brief that in the last 3 years there have been these laws. But before that, we might have had private societal discrimination. But I don't know of, but is there a history that I don't know about where we have de jure discrimination? And my concern about it is this. All of the other suspect classes that we've recognized so far do have that long de jure history of discrimination. And, the Equal Protection Clause applies to state action. So it feels like an odd fit to say that in their private lives, people have discriminated against transgender people. Therefore, we're going to treat it as a suspect class for purposes of the Equal Protection Clause.
So I think you may be right that the discrimination, historical discrimination against transgender people may not have been reflected in the laws, but I think there's no dispute that there is a broad history here, and it hasn't just been confined to private actors. I think that if you actually looked at the facts, there's a wealth of evidence to suggest that transgender people throughout history have been subjected to violence and discrimination and maybe lost employment opportunities or housing opportunities, even in contexts where there might be state public employment at play. And of course, that's especially reflected now in the law, where there has been this, I think, attention and focus on trying to limit transgender people from being able to live and identify consistent with their gender identity in our society. So I don't even understand the state to be disputing the historical discrimination point. But if you're approaching this from the standpoint of saying, is this a group with a distinguishing characteristic that has no bearing on their ability to contribute and that needs some protection from the courts, I think if any group qualifies, this one does in light of the current laws and what might come in the future. And our basic argument is, if you can look ahead and say, maybe the states will ban medical care for adults who are transgender, maybe they'll ban adoption by transgender people or not allow them to be teachers, that doesn't look anything like the workaday economic regulation that just gets rational basis review. And I think the court could give effect to that intuition.
Yeah, and I don't want to be misunderstood to say that I don't think there's a problem or that there hasn't been private discrimination. I guess it doesn't seem analogous to me to say race or gender or national origin, those kinds of things, because we did have de jure discrimination to point to. And so I guess what I'm thinking is, when we are in the business of identifying suspect classes, in Cleburne, we expressed, and I'm not saying that this is analogous to Cleburne in that respect, but we expressed in Cleburne hesitancy, to identify groups such as the elderly, or the mentally disabled as suspect classes, in part because those are judgments that are pretty hard for courts to make. And at least de jure discrimination of the sort experienced by women, or people on the basis of race gives us something to point to if we're going to be identifying a new suspect class, which we haven't done for a long time.
Yeah, and I, of course, take that point, and I should reiterate, we don't think the court has to confront it here. But in the cases involving age and disability, I understand the court to have approached those issues with somewhat different reasoning, that age is something we all experience, that disability is a broad and diverse group, and that individuals with disabilities have been able to harness the...
I don't hate everyone, J-Rock. I just hate you. Just making that clear for the record.
The majoritarian political forces to protect their rights, and none of that is true here. Transgender individuals are a discrete minority. I think there's no dispute that they are being subject to a wave of legislation across the states today. And I think that this is the kind of circumstance where the court could rightly recognize that heightened scrutiny should apply.
Last question. Do you agree with me that the resolution of this case has no impact on the parental rights claim that the Sixth Circuit also addressed?
That's right. I think we are not making a substantive due process parental rights claim here, and this court obviously didn't grant review of that issue. I will say that I think parental rights are actually relevant to the Equal Protection Clause as well, insofar as it's significant to me that Tennessee, in choosing to categorically ban this care, is taking a sharp turn away from how it ordinarily handles parental rights in the medical decision-making space. And Justice Kavanaugh said, who decides here? But when it comes to medical risks and benefits, the state's general approach is to say parents get to decide along with their doctors and their children. And so I think from the standpoint of under-inclusivity, it's pretty significant that Tennessee now is completely overriding parents' wishes when they are best positioned to know their individual child and to have a good sense of whether the risks of this treatment are outweighed by the benefits.
But this isn't, I guess my point is, even if we decided that this wasn't a sex-based classification that triggered intermediate scrutiny, that would not prevent parents from still asserting the substantive due process right.
Yes, of course, I agree with that. I do think that the sex-based classification under Equal Protection Clause is the most straightforward way to think about what's going on here, though.
Yeah, thanks.
Justice Jackson?
So I'm glad that you've clarified that how we characterize this law is really the issue on the table today, not the risks or benefits or the policies that justify it, but how we characterize it. And
all right, kids, strap in. Here we go. You want to hear some dumb shit? Let's get to it. Let's get to it.
I guess I think there might be some confusion a little bit. At least I'm confused because there's so many lines that this statute could draw. The classification, as far as I can tell, is a line drawing, is the statute drawing
Hey, J-Rock,
lines.
check
And there
your
are lots of
DMs
different
real quick.
ones. And Tennessee says this is drawing a line between people on the basis of age and purpose. And I totally see that. You say this is drawing a line on the basis of sex. I see that as well. But I guess my sort of initial question is, are those mutually exclusive? Do we have to choose between those characterizations? Isn't there a world in which this statute is doing both of those things? And the question for equal protection purposes is, if you're right that there is a sex-based line being drawn, then to the extent the plaintiffs are implicated by that line, don't we have to apply heightened scrutiny in evaluating their claims?
Yes, that's exactly right. And I think, of course, you could say this is a statute that classifies based on age and purpose and sex. Critically, we think that purpose incorporates sex here because the purpose is expressly defined in terms of treatments that are inconsistent with sex.
Right.
So I think the problem with the state's approach is to say, well, it's just purpose going on. You take one look at that, and that just dissolves down into drawing a sex-based line itself.
Can we put more flesh on that, though? Because, I mean, even if we separate.
This is the big thing here. What is a woman? And she's going to talk in this case, which I don't. It gets better when she grills the state of Tennessee, but yeah, this is just. She's laying the foundation for derping out, chat.
Out their age and purpose, and we just say, okay, so how is this actually drawing a line on the basis of sex? I think I heard you say it a couple times with respect to some examples, but I think it would be helpful to get on the table exactly who's falling on what side of the line in a particular situation related to sex.
Yes. So the way that the sex-based classification is working here is that from the standpoint of any individual who wants to take these medications, their sex determines whether SB1 applies. John Doe, one of the plaintiffs, wants to take puberty blockers to undergo a typical male puberty. But SB1 says that because John's sex at birth was female, he can't have access to those medications. And if you change his sex, then the restriction under SB1 lifts and it changes the result. And my friends say, well, that also simultaneously changes the medical purpose of using these medications. We don't dispute that point, that it might also inherently change purpose when you're changing sex.
But it doesn't have to, right? I thought of an example in which we have a plaintiff, a person a minor, who would like to take this medication to affirm their gender as a male because the medication deepens their voice, for example. They want a deeper voice and they're biologically male. They're taking the medication because that's what they want. They, I think, can get that medication.
That's right. And
but a person who is biologically female who wants to take the medication for that same purpose, to deepen their voice because they would like to live as a male, can't get it. Is that right?
That's correct. And that is on the basis of their sex.
So the purpose is held constant with that example. It's not changing. What is changing is just the biological sex of the individual.
I think that that's correct. But even in a circumstance where you might characterize that as treating delayed puberty instead of gender dysphoria, if you said, well, there is a different purpose there, even though the effects are exactly the same and they want the medications for exactly the same reason, that doesn't eliminate the sex-based classification because sex only has to be one but-for cause of disparate treatment. And I think the state will say it's perfectly reasonable to treat different medical purposes or uses differently. We don't disagree, but that's something that's channeled to the application of heightened scrutiny. And if the state has a really good reason to say there's a danger in using these drugs if your birth sex was female and you want to deepen your voice,
right? That's Justice Alito's studies in all of this. That all
goes to the application of heightened scrutiny, and maybe the state can prove it up and show they have an important state interest and they really have a reason to distinguish between these drugs for which purposes based on their sex. But that doesn't eliminate the facial sex classification or provide a reason for this court to turn its back on 50 years of precedent saying, if you classify based on sex, you have to justify that.
And it's interesting to me that you mentioned precedent, because some of these questions about sort of who decides and the concerns and legislative prerogatives, et cetera, sound very familiar to me. They sound in the same kinds of arguments that were made back in the day 50s, 60s with respect to racial classifications and inconsistencies. I'm thinking in particular about Loving, and I'm wondering whether you've thought about the parallels, because I see one, as to how this statute operates and how the anti-miscegenation statutes in Virginia operated.
Yes, and I think the court has recognized that the Equal Protection Clause was intended to force some changes in society and get us to think more closely about the way that people were being classified, including when that was based on overbroad generalizations of how we expect them to live and order their affairs. And the court has made that clear in the sex discrimination cases as well, where it said, sometimes these laws operate to disadvantage someone who falls outside the average description, and that person needs the protection of the court.
Well, and the thing I thought what was most interesting about the potential comparison to Loving is that in that case, everyone seemed to concede up front that a racial classification was being drawn by the statute. That was sort of like the starting point. The question was whether it was discriminatory because it applied to both races and it wasn't, necessarily invidious or whatever. But, as I read the statute here, the case here, the court starts off by saying that Virginia is now one of 16 states which prohibit and punish marriages on the basis of racial classifications. And when you look at the structure of that law, it looks in terms of, you can't do something that is inconsistent with your own characteristics. It's sort of the same thing. So it's interesting to me that we now have this different argument, and I wonder whether Virginia could have gotten away with what they did here by just making a classification argument the way that Tennessee is in this case.
Yes, I think that's exactly right, that there is absolutely a parallel between any law that says you can't act inconsistent with a protected characteristic, and in all other contexts, the court has recognized that as a facial classification based on that characteristic. And Tennessee even concedes the point when it comes to dress codes and to seeking a profession inconsistent with sex. But I think one other way to look at this, Justice Jackson, is that to me, it would be a remarkable proposition for this court to say that a statute that on its face says you can't have medications inconsistent with your sex, and in part that's because we want you to appreciate your sex, isn't drawing a sex-based line in the first place. That would have no correspondence to or grounding in the text of the statute or how it works in operation or what effects it produces for individuals on the ground.
Thank you.
Thank you, counsel.
Okay, chat. Yeah, I mean, here's the thing, 10K view. These people are talking very esoterically, and you're like, what the fuck am I? So the issue is whether or not, once again, this violates the Equal Protection Clause. Now, this part here coming up with Chase Strangio, I actually feel bad for Chase. Because literally the first question off the bat, and it just shows Chase was brought along as kind of like a novelty. And I think it was actually kind of bullshit what happened here. But we're going to get to that. So anyways, the Solicitor General just got done, and there's going to be the ACLU's lawyer is going to speak now.
Mr. Strangio?
Mr. Chief Justice, and may it please the court.
And yes, guys, you're like, what? This is a biological woman speaking.
On its face, SB 1 bans medical care only when it is inconsistent with a person's birth sex. An adolescent can receive medical treatment to live and identify as a boy if his birth sex is male but not female. And an adolescent can receive medical treatment to live and identify as a girl if her birth sex is female but not male. Tennessee claims this sex-based line drawing is justified to protect children. But SB 1 has taken away the only treatment that relieved years of suffering for each of the adolescent plaintiffs. And critically, Tennessee's arguments that SB 1 is sex neutral would apply if the state banned this care for adults.
That's what they're doing.
By banning treatment only when it allows an adolescent
Oof,
to live,
don't let Noel know this.
identify, or appear inconsistent with
know.
their birth sex, SB 1 warrants heightened scrutiny under decades of precedent. Because the Sixth Circuit failed to apply that standard, this court should vacate and remand. I welcome the court's questions.
Now,
here, listen to this part, guys.
You are successful. What would your remedy be?
Your Honor, if we're successful here, the remedy would be to enjoin the state of Tennessee defendants from enforcing SB1 as applied to our individual plaintiffs.
So in practical terms, what would it be? What would you get? Wouldn't you get you would get different treatment based on sex?
In practical terms, what it would mean is that an individual like John Doe, who is receiving medical treatment to undergo a typical male puberty prior to SB1 and is now barred from doing so because his birth sex is female, could then receive that treatment as he had been doing with the consent of his parents. So his sex would no longer be the basis for the denial of the medical care that his doctors recommended and his parents consented to.
Counsel, is there any significant respect in which your position departs from that of the Solicitor General?
So we're going to rewind that real quick, just so you can listen to this. Listen to this question.
Parents consented to.
Counsel, is there any significant respect in which your position departs from that of the Solicitor General?
No, Your Honor. The only argument that we make before the court here that the Solicitor General has not advanced is that this is a law that fails under any standard of.
No, I mean, think about that. And this is the one thing that actually did very much upset me. So, Chief Justice Roberts says, "Does are you just up like you're basically using the same argument?" Yeah, pretty much. I mean, it's like they trotted it. It's like they trotted her out just to be like, "Look, we have a heckin' trans person here, and look, the trans person's a heckin' lawyer." Give us some Reddit upvotes for that. Now, Chase could be in on it, fine, but I kind of get the feeling they kind of gassed Chase up to like, look, brah, you're going to go for the Supreme Court. You'll be the first heckarino, transgenderino in front of the Supreme Court that's ever been documented. Like, you'll be history. And it's like, oh, goody, what am I arguing? Oh, you're basically filling in and parroting out what the Solicitor General said. You're not breaking new ground or anything. Well, we're going to get to what happens when Chase starts, we're going to see what happens. But I'm just saying, like, this is actually kind of offensive. They're basically using the person as a novelty item. And I do think that's fucked up, regardless of who they are. Yes, that Chasing Strange. I know, that's Chase Strangio. That's the thing there. Nick says this season of Suits really jumped the shark. Oh, no. Hold on. And Sellers, here's the thing. I actually saw some of this afternoon. Chase went around the media kind of like being like, they made themselves into a novelty item. Yeah, but I just, it's so, people turn themselves, like, voluntarily turning themselves into the, just as like a heckin' conversation piece. And it's like, why would you do that? Why would you do that? Because next we're going to see what happens here, and Chase is going to fucking crash and burn very quickly. Very, very quickly. So.
Review. That it is so discontinuous with the asserted interest in protecting children and therefore fails under any standard. But we think, as the Solicitor General made clear in her remarks, that it is clearly a sex classification on its face and should be resolved on that basis and remanded for the Sixth Circuit to apply that standard in the first instance.
Is there anything you would like to add? And maybe there isn't, but with respect to the Solicitor General's responses to my concern that this is unlike a case like Craig versus Bourne, unlike a case like Morales, and those where it was quite clearly simply stereotyping with respect, can men have the same rights as women with respect to adoption and the liquor laws. This does strike me whether whatever you think about the disagreements between where Europe was some years ago and where Europe is now, where Europe is, where the United States is, in that it is quite a distinct type of inquiry that involves medical expertise, predictive judgments in the medical area than in those cases?
I don't dispute, Mr. Chief Justice, that at the application of heightened scrutiny, there will be particular considerations that involve the underlying medical evidence, as there always is. But I don't think that it would break new ground to apply heightened scrutiny here. The purpose of applying heightened scrutiny has been because, in part, we don't know at the outset whether a classification is benign, and many justifications for sex-based differential treatment in law were defended on the ground of biological differences and were upheld by the court under rational basis. And the role of heightened scrutiny is not to make sex a proscribed classification. It is just to shift the burden to the state to show their work and show that, in fact, this is a law that substantially advances an important governmental interest.
Counsel, are there other situations, the Chief Justice's question just made me think of this, in which any of our levels of heightened scrutiny, whether they be intermediate or strict, require courts to make the judgment, the means ends calculation in this kind of medical context? Because I agree with you. I mean, I can see your point, like, well, you know, as a matter of logic, we should shift this to that stage, assuming that the suspect class is triggered and we say this is sex classification. But is there any other situation in which courts get into that in the tiers of scrutiny?
I mean, so I would point, Your Honor, to recent cases involving the COVID-19 pandemic, in which many cases came up before this court, in which the states were regulating, you know, undeniably in areas of public health and evolving science, and the court repeatedly made clear that yes, of course, the states have latitude through their police power to regulate, but when they do so in ways that classifies based on suspect lines or infringes constitutional rights, then heightened scrutiny remains the standard that the courts apply to ensure that the state is advancing an important governmental interest.
Yeah, I guess I'm thinking of some, can I just, this last follow-up, but even in those COVID-19 cases, you know, courts weren't, and we certainly weren't diving deep into the medical evidence and comparing Europe and America and looking at research. I mean, this would be, I think, of a different order. Do you agree?
I don't agree, Justice Barrett, in the sense that I do think it is precisely the role of the courts to assess the tailoring and look at the evidence, whether it's presented through expert testimony or not. It is not the role of the court necessarily to say definitively these risks outweigh these benefits or vice versa, but do what the district court did here, which is to look at the assertions of harm, make comparisons to how Tennessee treated all other medical care, and then see whether or not Tennessee had met its burden under heightened scrutiny. That type of tailoring inquiry, I believe, is precisely the role of the court.
Counsel, in the COVID, I have a colleague to my right, whom I think very highly of, who spoke about the need of the courts to look at that evidence to ensure that there wasn't suppression of religion, correct?
That's correct, Justice Sotomayor.
Now, with respect to Justice Barrett's question on COVID, in my mind, it's a little more similar to the bathroom situation, because there, COVID was a risk not just to the individual and the threat to their own life, but their contact with others could threaten others. So the compelling state interest was different than just a pure medical issue, correct?
That's correct. I totally agree. The state interest was different.
All right. With respect to treating that issue, you can hear from some of my colleagues that they're worried that, and there is a plethora of science in this area, both that developed in Europe and the lower court hasn't really looked at it. No one has. That courts are ill-suited to that. Why do you think they're not? What about the fundamental role of the court makes us suited to answer those questions?
Well, I think first, Justice Sotomayor, the role of the court is to ensure that when the government draws lines based on suspect classifications, that the states are tested to ensure that they're substantially advancing an important governmental interest. And when it concerns underlying questions of medicine or science, the judges and judges in the lower courts have every ability to assess the testimony before them, as the district court did here. This is not an area where I believe Tennessee is saying that medicine is altogether an area in which suspect classifications have no bearing on the judicial inquiry. It is precisely the role of the court to ensure that the government of Tennessee has substantially advanced an important governmental interest.
I have one small question to finish with. The regret issue that was raised to the Solicitor General. Respondents cite a figure of 85% of children expressing gender dysphoria regret later. You use a figure of 1% of minors who receive this treatment expressing regret. Can you tell me where those figures lie?
Chat, there's a spot where this drops out with the figures. So,
expressing regret and the 85%?
I don't know he's pregnant,
Certainly,
Gary.
Justice Sotomayor. And so the first point I would say about the 85%, and we addressed this on page 22 of our reply brief, that's a misleading figure for two reasons. I think most critically, it refers to older studies of prepubertal children. And everyone here agrees that the medications that are banned by SB1 are only prescribed to individuals after the onset of puberty. And so in JA 151 to 153, the evidence shows that once an adolescent reaches the onset of puberty, their likelihood to ultimately desist and identify with their birth sex is very low. And then as to the question of the 1%, the question of regret, which is a different question than what happens with prepubertal children, the record shows there that the rate of regret when people receive this medication after the onset of puberty.
Listen to the tap dancing here. Chase is tap dancing through a minefield right now.
Is as low as 1%, and that's in JA 131 to 133. And I think what's important here, and the Solicitor General mentioned this, is that is exponentially lower than the rates of regret of treatments that are expressly permitted by SB1.
Thank you, counsel.
Could we explore what intermediate scrutiny might look like in operation in assessing laws like Tennessee's?
Uh-oh, here we go, chat. Here we go. Uh-oh. Uh-oh!
So the Solicitor General,
fucking Machine Gun Sammy, here he comes.
On page 48 of her brief, lists a lot of things that she says, well, if Tennessee were really concerned about the health and welfare of these minors, it would have taken into account a variety of things. So one is waiting periods. Another is whether puberty blockers should be exempted. Another concerns things to make sure that the future of these minors is properly respected, even though they personally cannot make mature judgments about potentially irreversible procedures. So she mentions things like two-parent consent or counseling, readiness criteria, age recommendations, licensing, certification, or reporting requirements for physicians, and other guardrails which are not specified. So if intermediate scrutiny were the regime that would apply, would it not be the case that judges would have to decide whether a particular package containing this much of that and that much of the other thing is sufficient? Wouldn't this be endless litigation with the decision based on determinations by lay judges regarding complicated medical issues?
So if I could make 2 points in response, Justice Alito. And the first is going back to the Solicitor General's example of West Virginia, where West Virginia looked at the underlying science and instead of categorically banning this medical treatment, created pathways with guardrails for individuals to access medical care. There has been no litigation over West Virginia's law. And if there were in other contexts, the question would remain whether or not the state could make out the showing that this is being treated in such a substantially different way than other forms of medical care. I do think that judges are equipped to make those determinations as they do in many other contexts.
A lot of categorical statements have been made this morning in argument and in the briefs about medical questions that seem to me to be hotly disputed. And that's a bit distressing. One of them has to do with the risk of suicide. Do you maintain that the procedures and medications in question reduce the risk of suicide?
I do, Justice Alito, maintain that the medications in question reduce the risk of depression, anxiety, and suicidality, which are all indicators of potential suicide.
And do you think that's clearly established? Do you think there's reason for disagreement about that?
I do think it is clearly established in the science and in the record. I think, as with all underlying questions of it, looking at evidence, there can be disagreement. I don't dispute that. But here, and sort of going back to questions about the Cass review, for example, the Cass review only looked at studies up until 2022.
Well, I don't regard the Cass review as necessarily as the Bible or as something that's true in every respect. But on page 195 of the Cass report, it says, there is no evidence that gender affirmative treatments reduce suicide.
What I think that is referring to is there is no evidence in the studies that this treatment reduces completed suicide. And the reason for that is completed suicide, thankfully and admittedly, is rare, and we're talking about a very small population of individuals with studies that don't necessarily have completed suicides within them. However, there are multiple studies, long-term.
So there we go. The whole suicide narrative is bullshit. Literally. Like I said, guys, this is a bad thing. He literally, Alito goes up and says, is this bullshit? Chase goes, well, yeah, it kind of is. Literally just lighting his fucking arguments on fire. The foundation's on fire. But yes, guys, if you guys don't know this Cass study, this Cass review was damning. It's really bad for the transgender movement and the medical community. It's so bad. But here you go. Like I said, Machine Gun Sammy, he set up a trap, and Chase was like, I'm gonna run right to this minefield. And it keeps going. It keeps going here.
Longitudinal studies that do show.
Right. Why should we care about these kids? Because it's our duty to make sure kids aren't butchered and treated poorly. So we should care about them. Kids should not be worked on by Dr. Mengele. So. Bab says, was the decision made yet? No, this is just from today. So no, they have not made a decision, but by the end, you can tell where this is probably going to go. So Maddie says, disagree. Well, no, I don't think these kids should be subjected to things like that. We're letting kids get butchered and for the whims of a community and societal pressure, and I think it's wrong. So. Yeah, it's society has a duty to protect children. They are the future, really.
That there is a reduction in suicidality, which I think is a positive outcome to this treatment.
Let me ask a question about another issue that came up during Justice Kagan's questioning and Justice Barrett's questioning in particular, and that is whether transgender status should be regarded as a quasi-suspect classification. And Justice Barrett referred to one of the things that our cases have mentioned in explaining when something should be classified as a quasi-suspect classification, and that is a history of discrimination. Another one is immutability. Is transgender status immutable?
May I answer, Mr. Chief Justice?
Sure.
So I would say that under this court's consideration of that criteria, it is a distinguishing characteristic. Transgender people are characterized by having a gender identity that differs from their birth sex. That is distinguishing and discrete. And that also within the characterization, I would also point if I could, to the history of discrimination, and there are many examples of in-law discrimination, exclusions from the military, criminal bans on cross-dressing, and others.
Thank you, counsel. I think I lost track of the discussion you were having about COVID. What was the point you were trying to make?
I think
Somebody was trying to make.
yes, I think it was me. And the point about COVID and the question of whether or not this court has ever considered applying heightened scrutiny to contexts in which states are grappling with evolving medical evidence. And I would point to Justice Gorsuch's statement in South Bay United Pentecostal, in which the purpose of heightened scrutiny, even when the government is grappling with experts of a medical character, is to still test whether or not that infringement on an individual right or that use of a suspect classification meets the heightened scrutiny standard. It's not exempt simply because it is in the context of public health or medicine.
Well, I don't want to relive the COVID cases.
You and me both, yeah.
But it does seem to me that one of the issues that came up, and as to which courts around the country had vastly different views, was the lack of knowledge about precisely what was going on, what the effects were going to be, what the remedies were going to be. If this is similar to that, I think that would be very troubling, to say that in such a evolving situation, we are going to decide what the right approaches are. I mean, you said at some point that the Tennessee court, or not the Tennessee court, this court is just as qualified as Tennessee to make the decisions here. And it's not really so much a question of qualifications, it's more questions of constitutional allegation of authority. And, we might think that we can do just as good a job with respect to the evidence here as Tennessee or anybody else. But my understanding is that the Constitution leaves that question to the people's representatives rather than to 9 people, none of whom is a doctor. Particularly and maybe I'm just repeating myself, but you can look, should we follow the United Kingdom position from 3 years ago? Should we follow the United Kingdom's position now? It seems to me that it is something where we are extraordinarily bereft of expertise.
Well,
anyway, just what you think.
Mr. Chief Justice, if I could first respond to the first half of your question about whether or not this is comparable in terms of the underlying science with respect to COVID-19, and I think absolutely it is not. I merely use that example to say that the court has not hesitated to suggest that heightened scrutiny applies in contexts that deal with medicine and science. And then with respect to what is the role of the courts, I continue to think it is to test whether or not a law is properly tailored, and that is what the district court did here. And in fact, the underlying science and the evidence showed that Tennessee's assertion of harm and their prevalence were not supported. The district court made factual findings to that effect, of which Tennessee has not argued were clearly erroneous. And so if what is left here is just bare rationality review, Tennessee is in essence saying, let's not look at the evidence at all, whether this is a law that bans this medical treatment for minors or for adults, that in all other contexts, what Tennessee does is recognize that there are risks and there are benefits. And usually the state regulates by informing patients of the risks and tailoring to minimize them. Here, what they've done is impose a blunderbuss ban, overriding the very careful judgment of parents who love and care for their children and the doctors who have recommended the treatment.
Thank you. Justice Thomas?
The point I was getting at with respect to remedies is normally in equal protection cases, there's a difference between one group and another. In Bourne, it would be that the women could buy alcohol, but the male students could not. And what would that be in this case?
So 2 points, Your Honor. I think that what the birth males can do that birth females cannot do is receive medical treatment to live and identify as boys. And what birth females can do that birth males can't do is receive medical treatment to live and identify as girls. That's
okay, let's change. would you make the same argument if we were only talking about puberty blockers?
If it was puberty blockers, I would point to John Doe, who is receiving puberty blockers. The purpose of receiving puberty blockers for John Doe is so that in the future he can undergo a typical male puberty.
No, I'm talking about from an equal protection standpoint, the difference in treatment. Normally in these cases, one group receives something that the other group does not. And I'm trying to discern that in this case.
And so what I would say to Justice Thomas is that a birth sex male can receive puberty blockers to undergo a typical male puberty, and a birth sex female cannot. And if I could slow it down and just explain a little bit how that works. If you're someone who was born.
Yeah, don't worry, Chad. Sorry, I had to look away. I had to answer something. When they get to the point of schizophrenia and how that's not immutable, like, yes, Chase goes on to admit that this is not immutable. Yes, like I said, Chase shits the bed here really bad for their movement. Now, granted, guys, remember, oral arguments don't usually make or break your case. The arguments in the briefs are there. This just helps flesh them out. So, while Chase is nosediving here, it's not destroying it ultimately. It's going to get destroyed under the grounds.
Born male and you are going through puberty too early, you want to be able to have a final adult height that is typical of boys. You may receive puberty blockers so that you can develop as a typical boy. Someone who has a sex of female at birth is also receiving puberty blockers so that they can undergo a puberty like other boys. And so it is the same purpose. Mm-hmm. And what makes the treatment prohibited for the birth sex female is their sex.
Justice Alito?
Counsel, I don't think you had a chance to finish answering my question whether transgender status is immutable. You cited a bunch of other criteria, but is it immutable?
I think that the record shows that the discordance between a person's birth sex and gender identity has a strong biological basis and would satisfy an immutability test. And I also think under this court's precedence for determining whether something is a suspect or quasi-suspect classification, a distinguishing characteristic is sufficient.
Does the category of, does transgender status apply to individuals who are gender fluid?
I think that the distinguishing characteristic is to have a birth sex.
Chat. Here we go. This is a problem.
That does not align with, or a gender that does not align with one's birth sex. So it may include people who have different understandings of their gender identity, but I think it is still the distinguishing characteristic of a birth sex and a gender identity that are incongruent.
Are there individuals who are born male, assigned male at birth, who at one point identify as female, but then later come to identify as male, and likewise for individuals who are assigned female at birth, at some point identify as female, identify as male, but later come to identify as female? Are there not such people?
There are such people. I agree with that, Justice.
So it's not an immutable characteristic, is it?
Well, I think people's understanding of it shifts, but the evidence shows that there is at least a strong underlying basis. And I think the normative reason for that particular consideration is whether or not this is something that someone should or could change, and whether they should have to change it in order to receive constitutional protections. And I think transgender status squarely fits within that.
We have said that having a disability is not a suspect or quasi-suspect classification. So if we were to agree with you on the question of quasi-suspect classification, how could we justify saying, for example, that a person who is schizophrenic does not fall within a category that is not a law that category that distinguishes on that ground is not a suspect classification? I'm not suggesting that gender dysphoria is a disease, a mental illness. I'm not suggesting that at all. I'm just saying, how could we justify that different treatment?
I think that
immutable in the sense that there isn't any cure for it. There's been severe discrimination against people suffering from schizophrenia. At one point, they were locked up in hellish institutions. They can make a valuable contribution to society. Think of John Nash. How would we distinguish that?
Jesus Christ. Sammy is on a roll, chat.
Was this story based? Yes.
Very based, chat. Very based. Very based. Very, very based.
Justice Alito, what I think would be the difference is that in Cleburne, the court in essence said as to the distinguishing characteristic that this was a large and diffuse group of individuals who have different forms of disabilities, and that group of people had been able to secure some protection through the legislative process. But again, if this court certainly does not have to reach the question of transgender status as a quasi-suspect classification, SB 1 on its face hinges its prohibition on inconsistency.
Well, I understand that, but would you dispute the proposition that transgender status is a very broad category? Doesn't the American Psychological Society Association say it's an umbrella term?
I don't know exactly what the American Psychological Association says, but I don't dispute that there are people who fall within a transgender identity who may not fit into a binary identity. I still think that the distinguishing characteristic applies to every single transgender person, which is a birth sex that is inconsistent with their gender identity. And of course, here on SB 1, this is a law that I think is easiest to understand and in the most straightforward classification on the basis of sex.
Sotomayor?
So when asked whether you differed from the SG's position, I assume that if you win in this proceeding, what you're asking for us to reverse is the Sixth Circuit conclusion that rational basis review applied, correct?
That's correct, Chair.
Now, you think, as does the other side, that each of you should win on that question, but are you differing from the SG that should be remanded to the court below to apply strict intermediate scrutiny in the first instance?
No, Justice Sotomayor, we're not disagreeing.
Now, with respect to Justice Thomas's question, I'm not sure you answered it. You did in part, and you said the relief you're seeking in the lawsuit, assuming you win on the intermediate standard review, is to permit your plaintiffs to receive the medication other children receive. I don't know if he was suggesting that one of the things we can go up in discrimination or we can go down, which is, but I don't think we've even decided who makes that choice, because the other alternative is to block the usage of all of these drugs for all children, which would present a very different than Arlington Heights perhaps question, but the point is that what the relief is still something that has to be determined as well.
Well, so if I could clarify, Justice Sotomayor, I don't think that the relief we're seeking is for our clients to receive the medication. The relief we're seeking is for SB 1 to stop being a barrier to their ability to continue to access medical care and make the individualized assessments with their doctors. So it is just simply an injunction of the barrier to the medication that they had been receiving in Tennessee.
Got it. Thank you.
Justice Kagan? Justice Gorsuch? Justice Kavanaugh?
Two basic questions. So whether we apply rational basis or intermediate scrutiny, either way, you end up looking at the state's justification, and they are articulating a health and safety justification. So it's not simply morals legislation as they've described it, it's health and safety justification. And it seems that there are risks and benefits both ways here. So it's very hard to weigh those, at least as the briefing has set out the issues. If the treatment's barred, some kids will suffer because they can't access the treatment. If the treatment is allowed, these treatments are allowed, some kids will suffer who get the treatment and later wish they hadn't and want to detransition. At least that's how I see the positions set out in the briefs. And so there are risks both ways in here, allowing the treatment or not allowing the treatment. And how to choose there, is a very difficult judgment call, it seems to me, but it's one, it's a just difficult judgment call as a matter of policy. And then for us to come in, and this is repeating what I said earlier, but I want your reaction to it, for us to come in and to choose one side of that, knowing that either way, people are going to be harmed. There's no kind of perfect way out, at least as I've read the briefs here, where everyone benefits and no one is harmed, right? The difficulty of the issue is some people are going to be harmed. And then the question becomes, how does the court choose which group? Why isn't that a choice for policymakers as best they can to make that choice in the first instance? So I just throw that out there and take your reactions and anything you want to say on that.
Okay, so if I could just make a few points in reaction.
I had one more point,
okay.
Sorry, to add to that. And I don't think, with respect, that what you and the Solicitor General said, oh, we'll just send it back to the district court and they'll make fact findings. It'll be back here in a year and we're going to have this same discussion as I see it. So just to get you thinking about that too. Go ahead. Have at it.
So a few points, Justice Kavanaugh. And the first is I don't see this as the court choosing what is the appropriate response here. What I see the role of the court is assessing whether the choice that Tennessee made is one that they can justify under heightened scrutiny. And so that question is whether or not by taking this decision away from the adolescents, their parents, and their doctors based on claims of harm, that protects children and protects children from adverse side effects. And what I think the record here shows, and again, this is a preliminary injunction record, what it shows is that broad categorical ban does not advance that interest. That doesn't mean that a more tailored response would not advance that interest, in which you may be able to actually come out with a solution to ensure that you are protecting those who may come to regret this treatment, which are much, much smaller than those who benefit and find it medically necessary, something like West Virginia did. And I think the relevant inquiry here is whether what Tennessee did meets their constitutional burden because they use sex-based classifications to pass this law. And then on two quick other points that, with respect to the difference between rational basis and heightened scrutiny, yes, of course, it will be weighing the state's asserted interest in both circumstances, but there's a world of difference between rational basis and heightened scrutiny. And we think the Sixth Circuit got it wrong by simply applying rational basis here. And to the question of, well, is remand, a sufficient?
Well, can I just stop you there? If even under rational basis, if there were no benefit to anyone, then it would probably lack a rational basis. So I guess in the end, you still come down to their risks and benefits both ways. Either way you go here, and I don't know whether rational basis or intermediate scrutiny, however that gets applied, you still have to kind of look, is there a real justification here? I think you look at that either way.
And I think the difference under heightened scrutiny, there's a chance to look at the evidence in a much more substantial way and have the state come forth and show whether they've met their burden. In terms of your question, Justice Kavanaugh, about, well, is it sufficient to just remand it? It will be back up here again. I would say two things in response.
Guys, this is, like I said, I was going to leave this alone. Your reactions are kind of saying it for me. Chase is getting BTFO'd bad.
I think that there are often examples where there's a threshold question and it goes back down on the application of heightened scrutiny. And I do think an instructive case is Johnson versus California here, in part because it gives us some guidance for what happens on remand in the application of scrutiny. And that, of course, was when the court was considering whether or not to apply strict scrutiny to racial classifications in prison or Turner deference. And when the court reversed and said the wrong standard was applied, strict scrutiny still applies, and sent it back down, it did so with guidance that even under strict scrutiny, the lower courts could take into account the particular context of prison. And I think here, this court could send it back down with instructions to take into account the particular context.
And just one point there, you agree that there's some group of people who receive the treatments who later wish they hadn't and wish to detransition? I know you say it's a smaller group. I understand that. I just want to make sure you agree as a factual matter there is some set of people.
I agree as a factual matter, as there is in all areas of medicine.
And then on the sports question, I want to get your reaction as well, which is it logically and legally possible to apply intermediate scrutiny and say that the Tennessee law and the other laws like it do not satisfy intermediate scrutiny, but laws that limit women's and girls' sports to exclude transgender athletes would be constitutionally permissible? Is that legally and logically possible?
I agree with the Solicitor General that it's legally and logically possible, because in the application of heightened scrutiny, it's wholly different state interests that are being asserted.
Thank you.
Justice Barrett?
Mr. Trengale, I wanted to give you a chance to see if, I'm not sure if you named all of the laws when we were talking about de jure discrimination before. You mentioned bans on cross-dressing and bans on military service. And I had thought of the military service, but I didn't know about the statutes prohibiting cross-dressing. Could you think of others? Are there?
I mean, I would say that there are other examples that exist in which sometimes homosexuality and transgender status are sort of lumped together in discriminatory frameworks as language has changed. But I think the most salient to me would be the cross-dressing bans and the explicit bans on military service for transgender individuals.
Okay, and thinking about, when we identify suspect classes, the factors that we've considered, one of the ones that the Sixth Circuit addressed was political power. Do you have a reaction to the Sixth Circuit's discussion of that?
I would just say, Justice Barrett, that I think looking out at the country at the moment, that there is a significant challenge for transgender people to protect themselves in the political process, where you have laws excluding transgender people from places where they need to go in all aspects of life. And there is a difficulty in that type of majoritarian protection. I think that's precisely what the political powerlessness prong of the test accounts for.
Thank you.
Oh, yeah, he does. Hang out. It gets better.
I guess I'm suddenly quite worried about the role of the court questions and the constitutional allocation of authority concerns, because I understood that it was bedrock in the equal protection framework that there was a constitutional issue in any situation in which the legislature is drawing lines on the basis of a suspect classification, that it's a constitutional question that is being raised when that is happening as a threshold matter. And then you may get into why is it happening? What is the justification? And you've said here at the podium today that the different levels of scrutiny account for how strong the government's evidence has to be for doing that. And the court really holds them to it in a heightened scrutiny scenario. But the kind of initial issue is that a law is drawing lines on the basis of some suspect classification. Does that accord with your understanding of what we normally do? And that's a question for the court, because it's a constitutional question. Is the statute doing this, right?
Yes, I completely agree with that, Justice Jackson. That's precisely why we think heightened scrutiny applies here, because this is a statute that on its face draws.
All right, and to answer the question, is this statute doing this? I understood that we had a sort of two-step framework for looking at it, that we don't just kind of launch into an assessment of the evidence or why the state is saying that they're doing this, or the scientific basis for it, that we're looking at something else when we're trying to determine, is a classification being made, right?
Yes.
And I guess my real concern, and maybe I'll just ask you to react to my Loving parallel, because I'm getting kind of nervous, is that in Loving, those same kinds of scientific arguments were made. So I'm reading here where the court says the argument is that if the Equal Protection Clause does not outlaw miscegenation statutes because of their reliance on racial classifications, the question of constitutionality would thus become whether there was any rational basis for a state to treat interracial marriages differently from other marriages. On this question, the state argues the scientific evidence is substantially in doubt, and consequently, the court should defer to the wisdom of the state legislature in adopting its policy of discouraging interracial marriages. And so for me, this kind of idea that the way we look at it is not first, are you drawing these classifications, and then state, give us your evidence so we can make sure that there's a proper fit. If instead we're just sort of doing what the state is encouraging here in Loving, where you just sort of say, well, there are lots of good reasons for this policy, and who are we as the court to say otherwise? I'm worried that we're undermining the foundations of some of our bedrock equal protection cases.
I share your concerns, Justice Jackson. I think one of the things that's happening in this case is we're seeing a lot of concerns that come in at step 2 of the analysis being imported into that threshold question of whether a classification has been drawn in the first instance. Concerns about real differences between males and females. That is exactly what heightened scrutiny is intended to test in the application of heightened scrutiny. If Tennessee can have an end run around heightened scrutiny by asserting at the outset that biology justifies the sex-based differential in the law, that would undermine decades of this court's precedent.
Thank you.
Thank you, counsel.
Yes, that was breathtaking, wasn't it, chat? Anyway, here we go. Now here comes state of Tennessee. And I'm just gonna say, chat, when the state of Tennessee gets to talk to Justice Ketanji Brown Jackson, oh boy, this is it's gonna be something. It's gonna be something, chat. Let me tell you. But yeah, overall, chat, I'd say Chase didn't do a very good job. Just kind of crashed and burned there. Very bad.
Mr. Rice?
Mr. Chief Justice, and may it please the court. Tennessee lawmakers enacted SB 1 to protect minors from risky, unproven medical interventions. The law imposes an across-the-board rule that allows the use of drugs and surgeries for some medical purposes, but not for others. Its application turns entirely on medical purpose, not a patient's sex. That is not sex discrimination. The challengers try to make the law seem sex-based this morning by using terms like masculinizing and feminizing, but their arguments conflate fundamentally different treatments. Just as using morphine to manage pain differs from using it to assist suicide, using hormones and puberty blockers to address a physical condition is far different from using it to address psychological distress associated with one's body. The Equal Protection Clause does not require the states to blind themselves to medical reality or to treat unlike things the same. And it does not constitutionalize one side's view of a disputed medical question. Half of the states, Sweden, Finland, and the UK, all now restrict the use of these interventions in minors and recognize the uncertainty surrounding their use. These interventions carry often irreversible and life-altering consequences, and the systematic reviews conducted by European health authorities have found no established benefits. Politically accountable lawmakers, not judges, are in the best position to assess this evolving medical issue. The Sixth Circuit should be affirmed. I welcome the court's questions.
Both the SG and petitioner have suggested that a better approach would be the approach of West Virginia. What's your reaction to that?
Your Honor, my friend's arguments with respect to the alternative approaches is pure policymaking. That, as Justice Kavanaugh recognized throughout his questioning, they cannot stand up here and say that if these alternatives were imposed, that there would be no detransitioners. So they cannot eliminate the risk of detransitioners. So it becomes a pure exercise of weighing benefits versus risk. And the question of how many minors have to have their bodies irreparably harmed for unproven benefits is one that is best left.
I'm sorry, Counselor. Every medical treatment has a risk, even taking aspirin. there is always going to be a percentage of the population under any medical treatment that's going to suffer a harm.
Yes, chat. Yes. Giving children puberty blockers is just like taking an aspirin. It's just like taking Flintstone vitamins. Like, this is the wisest of the Latinas. The wisest of the Latinas, as she said. The wisest of the Latinas. Yes, Bayer has chewable puberty blockers now. Yeah. I mean, she's not wrong what she's saying, but yes, but the scale of risk is very different. Yes, J-Rock, you should be like insulin, because Sotomayor is diabetic. You'd be like, yes, Your Honor, you mean like insulin? Yeah. Yeah. So there we go, chat. This is just the derp keeps growing, chat.
So the question in my mind is not, do policymakers decide whether one person's life is more valuable than the millions of others who get relief from this treatment? The question is, can you stop one sex from the other? One person of one sex from another sex from receiving that benefit? So if the medical condition is unwanted hair by a 9-year-old boy who can receive estrogen for that, because at 9 years old, if he has hair, he gets laughed at and picked on, and his puberty is coming in too early. But a girl who has unwanted hair says, or has unwanted breasts, or a boy at that age can get that drug, but the other can't. That's the sex-based difference. It's not the medical condition is the same. And
we don't
but
agree.
You're saying one sex is getting it and the other's not.
We do not agree that the medical condition is the same. We do not think that giving puberty blockers to a 6-year-old that has started precocious puberty is the same medical treatment as giving it to a minor who wants to transition. Those are not the same medical treatment. And once
What
you
you're saying
recognize,
is you're still depending on sex to identify who can get it and who can't.
I don't think so, Your Honor. If a minor comes up to a boy, goes to the doctor and says, I want puberty blockers to transition, the answer will be no. If a girl goes up to the doctor and says, I want...
If a sex-neutral looking child walks into a doctor and says, I don't want to grow breasts, doesn't the doctor have to know whether it's a girl or a boy before they prescribe the drug?
I don't think so, Your Honor.
I got to tell you, I've made that mistake on children often. Look at one of them and think it's a boy, and I'm corrected, and it's a girl, and vice versa. I hope.
Yeah, Brandon. Why does puberty hit earlier now? Because things in the water supply. Yes, but there are times where children have hit puberty early in life. And yes, we will give them a puberty blocker to slow it down until they get to the right age. Because a 9-year-old going through puberty can really injure them. So puberty blockers do have a legitimate use. So do hormones. But yes, they're trying to use the exceptions to argue the rule. Saying 9 is not too young. Depending on how fast it goes, there can be some health concerns. So they might try to slow it down at times. No. Like I said, listen to this person. Listen to this nonsense here. Listen to this nonsense. Yes. And yes, it's turning the frogs gay, chat. Yes, it's just turning them all gay.
That you're not going to tell me you haven't made that mistake.
Well, I may have made that mistake, Your Honor, but I don't think that is an example.
I haven't made that mistake. It's generally not hard to figure out
Of where a sex-based line is being drawn.
Why not?
Because
please.
Because all that matters is the medical purpose for which the drug is used. So if the minor comes up, if you have a biological...
No, it's the same medical purpose. Her hypothetical is, I don't want to grow breasts. Same medical purpose. I'm trying to stop the development of breasts.
Well, Your Honor, I think that that likely would not be allowed under SB 1 for a girl.
For a woman who is, for a
I'm sorry.
girl, but
Yeah,
it
and it would
would.
also not be allowed under Tennessee law with respect to a biological boy.
Really?
Tennessee law doesn't just allow doctors to prescribe drugs without a medical purpose. They can't.
No,
prescribe
but the way I understood
testosterone
the law to work is it has to be inconsistent with your sex in order for it to be blocked. So I don't understand why a boy, I don't understand why it would work in the way that you're saying. Why wouldn't it be differentiating on the basis of gender? A girl who doesn't want to grow breasts for whatever reason could or could not get it.
does not want to grow breasts without a medical.
Cat, here comes the derp train. All aboard to Derpville.
Reason could not get it.
And a boy who doesn't want to grow breasts could or could not get it.
Could not get it if there was no medical purpose. There has to be a medical purpose for these drugs. All my friend's arguments rest on conflating different medical purposes.
But they couldn't get it not under this law, right? Because this law is operating around the inconsistency. So if they couldn't get it, it would be for some other reason, right?
But we have other laws in Tennessee law that prevent malpractice and that prevent the use of drugs for a non-medical
I understand,
purpose.
but this law is the one that is being challenged today, and we're trying to decide whether or not it's operating on a sex-based basis. And
Well, I don't think
we have so what about my lower voice hypothetical?
Yeah.
All right. So a biological boy comes in and asks for a hormone treatment to
Fat ones. I can vouch from experience.
deepen his voice in order to affirm his masculinity because it hasn't come and he'd like to deepen his voice. Can he get it?
If there's no medical purpose, no.
No, that's the medical purpose. I don't understand what you mean. The purpose is to bring on a deepening of their voice.
Let me try to rephrase.
Yes.
If there's no medical condition, the answer is no. You cannot use testosterone for purely cosmetic reasons. It's a Schedule III drug.
In this statute or in another statute?
In another statute.
Okay, so setting aside that other statute, we're looking at this one and how it operates. This statute says something about inconsistency with your biological sex, and that's what I'm trying to test. The boy comes in, he asks for a hormone treatment to deepen his voice, to affirm his masculinity. Can he get the treatment? Under this statute?
Under this statute, no, but under Tennessee Code annotated
The
63.
boy could not, under this statute, to get a medication that would deepen his voice?
If there was no medical condition, no.
That's the other statute. Under this statute, with respect
Under
to
this statute.
consistency, he could.
Under this statute, he could. Under
Okay.
63-6-21412, he could not.
I understand. Setting aside that other statute, under this statute, he could. Now, looking at this statute, a girl comes in biologically and asks for a hormone to deepen her voice in order to affirm the identity that she chooses, which is masculinity. I'm asking you, would under this statute, she be precluded from getting that treatment?
She wants to, I'm sorry, one more time, Your Honor.
She wants to get the medication in order to deepen her voice and affirm her masculinity.
Your Honor, I think if it's for the purpose of identifying inconsistent with their sex, she would be barred from doing that under the.
But isn't that the point, Mr. Rice, that if it's for the purpose of identifying with their sex, I mean, the prohibited purpose here is treating gender dysphoria, which is to say that the prohibited purpose is something about whether or not one is identifying with one's own sex or another sex. The whole thing is imbued with sex. I mean, it's based on sex. You might have reasons for thinking that it's an appropriate regulation, and those reasons should be tested and respect given to them. But it's a dodge to say that this is not based on sex, it's based on medical purpose, when the medical purpose is utterly and entirely about sex.
Justice Kagan, we think that is a slightly We think that's a request for a substantive right to engage in non-conforming behavior. We don't think it's actually drawing a line based on sex. And again, the only way that my friends can point to a sex-based line is to conflate the use of puberty blockers to address precocious puberty with the use of puberty blockers to transition. And those are fundamentally different treatments. They have different effects on the body. They're used for different purposes. I actually think my friend's response to Justice Alito's hypothetical regarding puberty blockers is devastating, because that law draws no different lines than the law that's drawn in SB 1. It just doesn't use the words inconsistent with sex. So we use the words inconsistent with sex to describe a single prohibited medical purpose. We do not use it to draw lines between males and females.
Counsel, I want to be clear about this. I assume you agree with me that no matter how difficult the science may be, and no matter how evolving it may be, at the end of the day, legislation on this subject is subject to judicial review.
Yes,
Is that correct? And I also want to be clear that the issue about the difficulty of regulating the science and attempting to figure out where to sort of stop and place the scale in the evolution is a matter that goes to the level of judicial review. Is that right? The level of the scrutiny that's applied?
Yes, Your Honor.
Okay, thank you.
Counselor, given your argument, you're saying your state can block gender treatment for adults too.
Your Honor, we think that if we're assuming a similarly worded statute, that there still would not be a sex or a transgender-based classification.
So you're licensing states to deprive grown adults of the choice of which sex to adopt.
Your Honor, I don't think that's a fair
That's what you're telling me, because you're saying to me rational basis would be the review for that kind of law for adults as well.
And this court has not hesitated to hold laws unconstitutional under rational basis review when they.
Brilliant legal analysis by Kagan, Sotomayor, and Brown, Jackson Brown. I know, Chad, I told you guys this was going to be a banger. It's a banger.
Are rooted in unsubstantiated fears and prejudices. That's exactly what this court did in Cleburne. And
That's
to the extent,
quite an interesting way to protect the population.
And to the extent, Your Honor,
I thought that's why we had intermediate scrutiny when there are differences based on sex, to ensure that states were not acting on the basis of prejudice.
well, Your Honor, of course, our position is that there is no sex-based classification, but to finish the answer, that to the extent that a law with dealing with adults would pass rational basis review, that just means it's left to the democratic process, and that democracy is the best check on potentially misguided laws.
So
when you're 1% of the population, when you're 1% of the population or less, very hard to see how the democratic process is going to protect you.
Well, Your Honor,
you blacks were a much larger part of the population, and it didn't protect them. It didn't protect women for whole centuries.
Mr. Rice, I have one factual question, then one legal question. The factual question is, the Sixth Circuit mentioned that this is an off-label use, that the FDA has not authorized. Is that still true? And is that just for children, or is it for adults too?
it's still true. I think with respect to both children and adults, I know with respect to children, I'm not certain with respect to adults, but we do think that that's relevant in the sense that the FDA, when it approves drugs, it does so based off of the purpose for which the drugs are being used. And we think that we are drawing the same type of distinction in our law between using.
I didn't know that's going to be live, but if it's live, I'll watch it.
Okay, my legal question is, I wondered if you had a response. You know, I was asking your friends on the other side about de jure discrimination and what we should take account of if we're thinking about whether transgender people should be a suspect class for purposes of the 14th Amendment. Do you have a response to that? What we should be thinking about, or whether do you know the history of de jure discrimination?
I do not know the history of de jure discrimination. I mean, our frontline position is that the court has gotten out of the business of creating new quasi-suspect classes, precisely because it's a very unprincipled test when it comes to creating these classes. And in some of the cases, political powerlessness means that you need protection from the majoritarian process. In other cases, it means can you gain the attention of lawmakers in the most recent Cleburne test? So the court has not applied any form of principled analysis when it comes to creating these tests. It's been an exercise of judicial power. And the intermediate scrutiny analysis that accompanies the quasi-suspect classification is no more principled, and the court has often struggled to apply that as well. So we don't think the court should even open the door for further judicial creation of new quasi-suspect classes.
Okay, and last legal question. I was just going to ask you one. I have a second one. Could you address Justice Kavanaugh's questions about what the implications of this case would be for the athletic context or the bathrooms context?
I would love to, Your Honor. So we think this is, we differ with our friends on the other side with respect to their argument is that, well, there's a sex-based classification in sex-separated sports, so necessarily that means that there's a sex classification, intermediate scrutiny applies. We are not actually seeing challenges to the sex classification. When these challenges are being brought, they're not arguing that we don't want there to be boys and girls sports. They're arguing we want there to be boys and girls sports. We just want to be classified based off of our gender identity. And so we think that is a fundamentally a transgender-based challenge and not a sex-based challenge if you are not actually challenging the sex classification that is at issue.
Can I ask you, so in my sort of loving parallel, Virginia, in your view, would not have been
and we're back to
racial
loving
classification if they had just reworded their statute to say no person can get a license to marry for the purpose of uniting with another person whose race is inconsistent with their own. I took you to say that the use of the term inconsistent with their sex was drawing a line to prohibit one use of the medication. So why couldn't these statutes have been interpreted as drawing a line to prohibit one use of a marriage license?
Your Honor, we think that in a case like Loving, when you look at the individual level, which we agree with our friends on the other side, that the protection of the Equal Protection Clause operates at the individual level, that if there is a line that is being drawn based off of race, like in Loving, where you had a white male who could not marry an African-American female under that law, that is a race-based line. You are creating multiple groups of permissible and impermissible behavior based off of race. Where we differ from our friends on the other side is we just don't think that there is any sex-based line in this.
But I don't understand why not. I mean, the law here operates in the same way. The question of can you marry this other person depended upon what your race was. You could marry the other person if it was the same, consistent with your race. You couldn't if you couldn't. I take your law to be doing basically the same thing.
Yeah.
You can get these blockers if doing so is consistent with your sex, but not if it's inconsistent. So how are they
this
different?
still doesn't work.
We think
This
it's
doesn't
different
work
because we think in their use of inconsistent with sex and all of these examples that they have in
this
the
is
briefing,
awful.
Those actually do create separate categories of conduct that is permissible either based on sex or based on race. But in this case, the only way that they can point to a sex-based line is to equate fundamentally different medical treatments. Giving testosterone to a boy with a deficiency is not the same treatment as giving it to a girl who has psychological distress associated with her body. This is not only
what's your
different.
basis for saying that? I'm sorry. Is it just because of why they're asking for it, or is there some kind of medical? I took the SG to be saying that it operates on the body in the same way. So what's your basis for saying they're not the same?
I don't think it operates on the body in the same way. Take testosterone. If you give a boy with a deficiency testosterone because he has constitutional delayed puberty, that allows him to go through and develop the reproductive organs associated with being a male. If you give it to a girl, it renders the girl infertile. So we have 8 to 12-year-olds.
Oh, I'm sorry. I thought your reasons for them being different was that you said they were for different purposes. I'd heard you say at the beginning, the reason those two are different is because one wants them to transition and the other wants them for some.
And that's literally what he just said. I mean, listen to this woman.
Medical purpose.
Well, to go back to my example in the introduction, I don't think anyone would say using morphine to assist suicide is the same treatment as using morphine to manage pain. It's the
That's
same
a very
drug,
good argument.
just like it's the same drug here, but they're being used for fundamentally different purposes. They have different effects on the body. And once you take out and you recognize medical reality, then there is no argument that our law differentiates between treatments for males and females.
Can I ask you about one of the purposes of this law? And I note that your brief does not talk a lot about this, but one of the articulated purposes of this law is essentially to encourage gender conformity and to discourage anything other than gender conformity. And I'm wondering how you think that plays into the analysis.
I disagree with that characterization
Well,
of our law.
encourage minors to appreciate their sex and ban treatments that might encourage minors to become disdainful of their sex. Sounds to me like we want boys to be boys and we want girls to be girls.
If I could,
and that's an important purpose behind the law. And I understand that sentiment, but it's a fundamentally different sentiment, and it's a fundamentally different understanding of what produced this law than the one that you're talking about now.
Your Honor, if I could make a few points. First of all, it sounds like the question is rooted in a potential improper purpose-based argument under our Arlington Heights argument, which, as Chief Judge Sutton pointed out below, that argument was never raised until it got to this court.
Well, I'm less interested in sort of like the legal box to put this in, and more interested in, you know, you're spending a lot of time talking about what exactly the classification is here, and I think we've talked a good deal about that. But what produced this classification might be relevant to understanding what the classification is about.
Absolutely, and I would love to address.
And what seems to have produced this classification is that we want to ban children treatments that might encourage minors to become disdainful of their sex. So we think that there's something fundamentally wrong, fundamentally bad about youth who are trying to transition. And that's the way this purpose seems to me.
If I could try to unpack both of those, Your Honor, because I think both of those read in context do not support the narrative that Tennessee wants boys to live as boys and girls to live as girls. So the appreciate their sex reference in detailed in legislative findings, that is.
And, you know, Chad, I heard about this, you know, when she said this earlier. I don't care about the law. I do think part of your job when you're assessing the law is not only just the law, but public policy. Like, you can't just look at law in a vacuum, but it should be predominantly focused on the law. But yes, I mean, I can see Clarence Thomas saying that in a way that would make sense. But yes, with Kagan, she just sounds like a loon because she is a loon. But yes, this is your Supreme Court, ladies and gentlemen. Highest court in the land.
Is simply the recognition that given the high desistance rate among minors and given the tragic regret of detransitioners, that there is an interest in making sure that minors have enough time to appreciate their sex before undergoing life-altering changes. So I think that that has to be viewed in the context of the legislative findings, with which both emphasize the detransitioners and the high rate of desistance. With respect to become disdainful of their sex, the challengers have never explained why it would be problematic to prevent interventions that could affirmatively cause minors to become disdainful of their sex and thus at issue for psychiatric conditions. And in fact, there are multiple studies, I would point to this court, JA 400, where minors actually, their mental health and suicidality got worse after taking these interventions. Now, my friends on the other side may disagree with that research. And
I mean, shit, teenagers are suicidal in general. I mean, that's a normal thing.
Research and that assessment of whether the findings of that study, but the legislature specifically noted those studies. So I think that statement was rooted in the notion that actually this is causing affirmative harm to minors who are undergoing the interventions. And that's why they were saying we don't want these interventions that will cause minors to become disdainful of their sex.
Go ahead.
You go.
No, go ahead. No, go ahead. I'll be back.
Justice Kavanaugh.
At a big picture level, I think the argument on the other side, putting aside some of the details, is why not trust parents rather than the state particularly in a situation, as General Prelogger said, where there's not the kind of direct harm to third parties that you might see in other contexts like sports?
Yes, Your Honor. So as my friends recognize, the parental rights
Yes.
question is not before this court. And
She explained how it informs. So just take the question
Sure.
as best you can.
Yeah, I think our position is that there are certain times in medicine, history has shown where the states in their traditional role as regulators have had to intervene. And that's not because of course the parents are trying to do the best they can and get the best treatment for their kids. But we've had multiple instances in somewhat recent history where we have stuff like lobotomy, eugenics that had widespread acceptance among the medical community, and the state had to intervene as a regulator to protect the children.
Mr. Rice, just to let you kind of finish what you started to say to Justice Kavanaugh, you agree that the parental rights question is not before the court. So it would be open to parents to continue to press that point in other cases.
We agree, and we think Chief Judge Sutton got it right, but we agree.
Can I just ask you about, I don't understand at all the similarly situated argument that you make, and I hope that you can help me, because I don't know how you can say both that girls and boys are not similarly situated at step one when this law is being evaluated and it's not making a sex-based classification. It seems to me that recognizing their lack of similarity as you do in making the argument is making a sex-based classification. So
I think our position is that if you're in the point where we're treating giving testosterone to a boy with a biological deficiency as the same thing as giving testosterone to a healthy biological girl who wants to transition, then there has to be some threshold inquiry that recognizes the biological differences between those two.
Right, but when you're doing that, you're making a sex-based classification. I mean, the very argument carries with it the characterization that we're trying to identify here. You start by saying it's different to treat a boy who's using this medication for a particular reason from a girl who's, okay, so that's a sex-based classification. Haven't we dealt with step one now? We should be going on to step two. No. Intermediate scrutiny applies by the terms of what you're arguing.
I don't think that we agree that we've checked the box at step one, because there is no medical treatment that boys can receive that girls cannot. So we disagree with the notion.
Didn't we already dispose of that kind of
Yes, this woman is retarded.
Equal protection cases
Sadly.
that looked at things like interracial marriage, where we said, even though it applies to both, it's still making a racial classification. Even though whites can't marry non-whites and non-whites can't marry whites in the statute, right? So both are equally disadvantaged. We said that's not an argument for why you shouldn't have a heightened scrutiny or why the statute is not making a race-based classification.
And that's not the argument that we're making.
Okay, so what is
we are not arguing that you can discriminate and draw lines so long as you do so both against boys and against girls. We're arguing there is no sex-based line. If you're a boy and you go in to get puberty blockers, you can get the puberty blockers.
All she does is see things in terms of race.
If you're going to use them for precocious puberty, you cannot get the puberty blockers if you're going to use them to transition. That is not a sex-based line. That is a purpose-based line. So our fundamental point here is not that you can discriminate against both sexes in equal degree. Our fundamental point is there is no sex-based line here. And the only way they get to a sex-based line is by equating fundamentally different treatments that defy medical reality and defy how the statute itself sets out what is a treatment.
And the treatments are different because of the biological sex of the person, right? I mean, that's what you've said. The purposes are different because of the biological sex and why you're going in to get them.
Not at all. I mean, with puberty blockers, the purpose, nothing turns on sex. Take puberty blockers. There's nothing that turns on sex as to whether there's a sex-based classification there. Everything depends on what is the reason that you are using those puberty blockers for. Happy to take more questions if the court has them.
Justice Thomas?
A number of times you've mentioned off-label uses of these hormones. The what are some of the other off-label uses that are not legal in Tennessee?
So, for example, Your Honor, testosterone, we have a separate law that prohibits the use of testosterone for hormonal manipulation intended to increase muscle mass, strength, or weight without medical necessity. We have, like every state, we regulate medicine and we regulate the use of drugs. You cannot use drugs in the state of Tennessee if it's not for a legitimate, viable medical purpose. Here, through this law, all that we have done is make clear that these treatments, which are irreversible often, have significant effects on minors and often leaves them with bodies that are infertile and permanently damaged, that you have to wait until you turn 18 to receive those type of treatments.
A number of times you've tried to say that what the classification that the state of Tennessee has advanced in this legislation. Would you spend a few minutes on that?
Yes, Your Honor. So again, we think that our law fundamentally draws a distinction based on medical purpose. I'll go back to puberty blockers. If a boy wants puberty blockers, the answer is yes if you have precocious puberty, no if you're doing this to transition. If a girl wants puberty blockers, the answer is yes if you have precocious puberty, no if you're doing this to transition. That is fundamentally a different treatment, and what is dictating under this law is the use for which you are putting the drug. And just to kind of build out on the notion that these are not the same treatments, we talked about earlier testosterone. If you give it to a biological boy, it allows the boy to develop a normal body and healthy body, whereas providing it to a girl causes a physical condition, hyperandrogenism, and that results in clitoromegaly, atrophy of the lining of the uterus, blood cell disorders, increased risk of heart attack. So the notion that the risks are the same when you give testosterone to a boy as when you give it to a girl are simply not borne out by medical reality.
Justice Alito? Justice Sotomayor? Justice Kagan? Justice Kavanaugh?
Just one clarification. It's an obvious point, but I want to make sure you agree with it, which is you're not arguing that the Constitution takes sides on this question. You, as I understand it, you are arguing that each state can make its own choice on this question. So from your perspective, as I understand it, it's perfectly fine for a state to make a different choice, as many states have, than Tennessee did, and to allow these treatments, correct?
Yes, Your Honor, that's correct. And we think that's because of what Your Honor has pointed out, that no matter how you draw these lines, there are risk and potential benefits and harms to people on both sides. And the question of how to balance those harms is not a question for the judiciary, it's a question for the legislature.
Thank you.
Can states make a different choice if doing so means that a state's law operates to treat its citizens differently on the basis of name the suspect classification?
Oh, come on.
I thought that was the work of the Constitution and the Equal Protection Clause.
Your Honor, we don't think that it draws any lines based off any.
No, I understand. I'm not talking about this law. I'm going back to Justice Kavanaugh's suggestion that the Constitution doesn't play a role if the state is making a policy choice regarding issues such as these. And I guess I'm still seeing a role for the Constitution in circumstances in which the claim that is being made is that the state's choices are implicating the equal protection rights of its citizens.
Your Honor, I think the point, I don't want to misstate the point, but I think the point is that the Constitution is neutral in the sense that it does not provide heightened protection based on any suspect classification, and thus rational basis review applies in the presumption of legislative validity and the presumption that these types of policy choices are best left to the democratic process. I think that is exactly what the correct way to think about this case.
Thank you.
Thank you, counsel. Rebuttal, General Prelogar.
Thank you, Mr. Chief Justice. 2 quick clarifying points. I want to make clear that Tennessee here is not regulating based on off-label use. Off-label use is extremely common in pediatrics, and we've pointed to a number of uses of these medications on page 40 of our brief, the very same medications that likewise are off-label use. If there are problems with safety and effectiveness, then that would not become the standard of care, and there are self-regulatory measures to address that issue. Justice Kavanaugh, you said this might be a space where each state can make its own choice, but I think it's important to recognize that my friend's arguments would equally apply to a nationwide ban if this were enacted by Congress. And so I think that the court should keep that in mind when thinking about the level of scrutiny here. There were a lot of questions about how to take account of disputed medical evidence when there might be some uncertainty. And I want to make a few points. As my friend acknowledged, that doesn't go to the level of scrutiny. So that doesn't mean that you should ignore a sex classification when one exists in the statute. But at the point of applying heightened scrutiny, the court can take context into account. And we're not asking courts to step in here and say, we want to figure out as a matter of policy exactly what the right approach is. But you can ask the familiar judicial questions like, does the state actually have any evidence to support its claims that there's a harm to adolescent health? And is this law severely over and under inclusive? And if the court conducts the analysis here in the first instance, this law doesn't look anything like a typical medical regulation to protect adolescent health. That would look like the West Virginia law where you're tailoring it, but still leaving some possibility for care when it can have enormous benefits. And the reason it doesn't look like a typical medical regulation is because the legislature was doing something different in trying to get minors to appreciate their sex and not become disdainful. That's not a medical-based justification, but I think it shows exactly why the state drew the lines where it did. Finally, I think the court should think about the real-world consequences of laws like SB 1. Consider its effects on Ryan Rowe. As Justice Sotomayor noted, Ryan's gender dysphoria was so severe that he was throwing up before school every day. He thought about going mute because his voice caused him so much distress. And Ryan has told the courts that getting these medications after a careful consultation process with his doctors and his parents has saved his life. His parents say he's now thriving, but Tennessee has come in and categorically cut off access to Ryan's care. And they say this is about protecting adolescent health, but this law harms Ryan's health and the health of all other transgender adolescents for whom these medications are a necessity. And the state says it doesn't even want the courts to take a look at whether this protects adolescent health. But the reason Ryan can't have these medications is because of his birth sex, and a sex-based line like that can't stand on rational basis review.
No, it's not Ryan Cannell, chat.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until Monday next at 10 o'clock.
So that's it, chat. That's it. Woo! Poor RK Outpost. You guys stop. James Olinton Safa. So, all right, guys. I mean, like, I think it's probably going to be 5-4-6-3. They were making jokes about Ryan being transgender. So, you guys are, oh, no, stop. So anyways, guys, yeah, that's it. I think it's going to be a 5-4 or 6-3. It's not like, I mean, we know where this is going to go. At the end of the day. And I think the big thing is it's applied equally to men and women, so there's not a sex issue. And to argue transgender is now something you get to throw into the works there. Cayenne Renell. Yeah. It's going to be, I think there's no discrimination. It's equally denied. I have too much faith in the squishies. Well, I have to have faith in them because otherwise my job is pointless if I have no faith in courts. Any idea when we might get a decision in Vanderstock? Sometime in the spring, couple of months. So we got some super chats, other comments to get through chat. So we're going to knock these out here. Trump once says the fires of hell await those that give this to kids. I don't disagree. Afura is saying, if this is the case, as a heroin addict, I should be able to go to the ER and get heroin for my addiction. Yeah. Huh? Not disagreeing. Sir Fist says Justice Priligar will follow in Sotomayor's footsteps. Well, she is there's a reason why she was hired by Joe Biden. She is a Democrat. So yes, part of her job as being the Solicitor General is to argue for whatever the government wants. But she's been around. Like, she is, like here, if you guys didn't know this about her, like, after she graduated law school, she spent 3 years as a law clerk for federal judges, okay? Her first year as a law clerk, guess who she was there for? For actually 2 years. 2 years. Actually, hold on. No, for 3 years. So her first year as being a law clerk for a federal judge. If you guys didn't know, I'll show you. What's for this guy? You may know him. At the time, in 2008 to 2009, he was on the D.C. Circuit Court of Appeals. You may know him. That's Merrick Garland, the current Attorney General. So, yeah. It's kind of what she does. And then after that, she then became a clerk for this person. You may have heard of her. You may have heard of this judge. She was then a law clerk for this judge. You may know her as Ruth Bader Ginsburg. And wait, there's one more judge she was a clerk for. Another one. You may have heard of her. Elena Kagan, Supreme Court Justice. So she clerked for two. That's not like, that's kind of rarefied air, but yeah, there you go. So, like, you guys are saying, like, oh my God, she's a dingbat and all that. It's like, yeah, she is. There's a reason why Joe Biden hired her. She is a true believer in this shit. It helps. It helps. It's all coming together now. Yeah. Yeah. I take it good says, doesn't that compromise or bring case before the court? No. That's not a conflict in that situation. I wouldn't argue it is. But there you go. Yeah, so she signed for Ginsburg. Yep. Although Ginsburg in 2010, like, remember when she was clerking for Ginsburg, that was 15 years ago, chat. So Ginsburg actually had her shit together 15 years ago. So I'm just saying, like, when you guys talk about her, she has a pretty, like, decent history of being like, you're like, I can't believe she's doing this. Like, aside from being the Solicitor General, her job is to represent the United States. This is shit she's all about. She's all about that action. Kay says he'd love to listen to me give oral arguments. Here's the thing, though. It's different when you're doing oral arguments. There's a lot of ums and ahs when I've had to do it. So, no, you wouldn't want to listen to me. At some point, if I have one, I'll do it. I know Andrea Burkhart just put one up. She just did. I don't do them frequently, but the district I'm in doesn't normally do them. So it's not very common to normally ask for. But if I ever do one in the future, I'll definitely record it or see if I can get it recorded. There's another district court of appeals near me I'm trying to get on their appointed list for, just because they have tons of crap out there. And I know they do a lot of oral arguments, so that might be something to do. Foley says, though it's not anything you've aimed for since you haven't yet become the judge, would you like being on SCOTUS? I don't know. I don't think I would. I mean, as much as I joke about it, and I did send in like my resume and cover letter to Trump, I wouldn't like it. Because like you're kind of like it's like being an oracle. You don't ever get to interact with the plebs. Your life is completely different. Everybody fucking hates you. Like, half the country hates you. Half the country loves you on any given day. They treat you like you're some learned sage. And I don't know if I'd like that. I think, like, being a trial court judge, I think I would like, but I don't think I would like being a court of appeals judge. That's just not and this is an appeals. This is an appellate level thing, basically. That's not my speed. I appreciate the thought, though, but I don't think I would like it. Maybe I am suited for it, and I just don't know it. X is saying I sneezed too close to the sun. Governor Wolf says, Fat Icarus at least could fly. Couldn't have been that fat. Yeah, I'd have a heart attack from flapping my wings. Fat. Well, and Langman Vandevick says, Fat Icarus can't fly too close to the sun because he's fat. You fail to see the simple beauty of the scenario. Yes, he's too fat to melt his wings, so he'll never crash. I am invincible. Debbie says for $5, thank you for covering this. Well, you're very welcome, Debbie. And guys, I know you're asking about the assassination thing that happened today in New York City. We'll cover that tomorrow because there's a lot to go through. And now we've seen pictures of like the crime scene. Apparently the guy used like 9mm. Looks like he used a 9mm, not like a 22 like some people were thinking. So, and we'll get to it. We'll talk about as much of it as we can. Debbie O gifted 5 subs. Debbie O helping us pray the gray away, chat. Remember, chat, you too can help pray the gray away and turn this into a green chat. You can. By gifting subs. That's the way to do it. And Debbie, thank you for the support and the generosity. Maddie's saying, do all decisions not available to a child fall to a parent? Pretty much. I mean, think about it. Like, yeah, I mean, even when you're a child, pretty much all decisions are technically your parents. As far as they'll let you have them. D's been a member for 5 months. Thanks for the support, man. It's saying, this woman looks like a female sphere hunter. Jesus, no. Fat Icarus says, it's a parasocial sun. Just be careful, Sean. Oh, yeah, I don't want to get burned by that one. Angela says, I don't think any child under the age of 18 should be allowed to change their sex. They should never be allowed to go and undergo surgery or treatment. If they want to, like, wear, like, anything that can't be reversed should not be done. I still think that they should, whatever's going on, they should be working through therapy. But, like, you know, a chick wearing boys' clothes, that's something you can reverse. But going to anything that can't be reversed is a big problem. And even then, you let kids do it. Most kids desist on their transitioning. Like 85%, and that's actually a quote. And I listen to Sitch AM, they'll talk about it. They talk about it quite a bit. Most kids desist from their transitioning. It's very common. Brewberry says, you know, it's bullshit. I work in the plastic surgery field. We have to supply compression vests and custom sizes for teens getting mastectomies. Extra small in male sizing because a female vest is triggering. That's fucked up that you guys have to do that, period, though. But God, that's fucking grim. That's very grim. Fire PA says, rest in peace, Austria-Hungary. To the real one out there, chat. Tomorrow V saying, I only raised it, you know, we were talking about Europe and saying, yes, they hand wave about all Europe being the same. That's correct. Yeah, you go to the Balkans or you go to Eastern Europe, this is not the same thing. I agree. Ag is saying, cis and trans are double bonds, damn it. I know. I didn't realize that till probably 2-3 weeks ago. Those are chemistry terms. They stole science terms to church it up, chat. Cis and trans are fucking chemistry terms. And they did that. That's how they bullshit us. That's how they bullshit us, chat. They use the, oh God, we're getting more rain. The snow's gonna melt. They use chemistry terms. Tomorrow V says pharmaceutical castration is damaging to children. 100% it is. Fucking with the natural process is never a good thing. You know, we like Jurassic Park. Like, it is a very good point. Just because you can doesn't mean you should. Sula says, let's toss out 10,000 years of human socialization. No, toss out like 3 million years of human socialization. 4 million years of human socialization. I mean, like, you got to go back to like Australopithecus. Like when we had different human species, like different hominids were running around, like, Homo erectus, the Neanderthals, the Denisovian man. Like we had like there were breeds of people and species of people, and even they had gender roles. Preligar has lost her mind. No, this is her job, and she's about this. She's about this. Snoop says, I watched Kino Casino so I could feel slender. PPP's looking better than me, man. PPP's looking like he's taking care of business. So I can't say shit about him. Bebop and Rocksteady asked this is a good question. From a lawyer's point of view, would arguing at the case of the Supreme Court and losing, would that be better than never getting the opportunity in your career? Yeah, I would argue. I mean, you got to make it to the big leagues, dude. Like, you got to play in the Super Bowl. You got to play in the World fucking Series, dude. I mean, yeah, sure, you might lose, but would you take that shot? I mean, you're playing on the biggest stage in your profession. Yeah, I think it'd be awesome to be involved in a case going to the Supreme Court. That would be pretty fucking dope. That would be pretty dope. I think it'd be awesome. Even if you lost, it'd be like, my name's etched in there still. Snoop SCP says, of course she's going to be a big shill for Big Pharma. Of course she's going to lie. Well, no, it's just, I mean, yeah, Preligar technically is kind of shilling that way, but yeah. Yep. And Fruitfly says, but what if the kids change their minds? Oops. Go ask Chloe Cole what happens. Your life is, your ability to live as an adult is ruined. Shredder S07 is saying, SCOTUS, you better rule in our favor. This trans lawyer is going to kill himself. Pretty much. I kind of thought that was going to be the argument for a minute. Nero's saying, when Robert steps down and I become Chief Justice, will you please allow camera and audio equipment in the courtroom? You have no idea what I would do. Oh my God. We'd have TTS popping in asking questions. You'd be able to super chat the middle of it. Oh, God, it'd be great. It'd be great. That's a shame, says, if you boil it down, protecting children is the only purpose of society. Yes. Purpose of society is to keep society going and to keep, yeah. So, and I do think the state has an interest in making sure these kids are not attacked and injured. You know, these kids are not subjected to some Joseph Mengele shit. I agree. That's a shame. Good to see you. Hope you're doing well. Brandon, the anime guy, says, Chase Strangio. What the hell happened to that person? Daily reminder, we do not hate the ACLU and the DEI hires on the court enough. Yeah, the ACLU has sold out civil liberties at this point, pretty much. And it's about what they want and about their niche causes. Swizgar saying, good to see you, man. Thank you for stopping by. Saying, I think the conservative justice reserved their best arguments for Chase because they knew this would happen. Yeah, but I mean, like, that's part of the issue here. And like I said, I kind of I feel bad. You know, people gas Chase up and Chase goes out there and she's like, I can do this. And they fucking felted her. Like, in the fucking Supreme Court. Like, now Chase will be part of setting bad case law. Possibly for them. Like, that's a horrible thing. You're part of the movement. And you're like, look, we got the Hecarino trans lawyer, and they fucked it all up. It's like, that ain't a good look. That ain't a good look, man. I feel bad. Like, that was a horrible showing. I'd be like, that, like, fucking awful. Felt Earth Cult says, Plebit means Reddit. Deleted a subforum where people complained about the horrific side effects of bottom surgery and transitioning, and they were trying to hide. Yeah, Reddit's trying to hide reality. Yep. Oh yeah, they do. Brandon, the anime guy, is a new member. Thank you for joining us, Brandon. I appreciate the support. You know, and doing your own part to pray the gray away. You know, it only takes one, chat. It only takes one. Malcolm says, I watched Kurt's stream earlier. I don't know what Justice Jackson's point was supposed to be. I don't think she knows either. I really don't think she knows. The woman's confused. She's got issues. Well, that's the thing. I take it good. You know, women, like, that's the thing. When men transition into women, we're better. Like, we win all the competitions. We're so, like, women suck so bad. Like, men are even better at being women than women are. We're that awesome. Now, here's the thing, Harble Warble. They lost yards. Yeah, but this wasn't like a pick six. But certainly they did not get the result they're looking for, and they'll have to come back when they can find a more sympathetic court. But this wasn't like a complete like pick six, like, you know, you're fucking Jameis Winston just fucking throwing pick sixes all night long. It's not one of those, but it's not good. It's never good to throw a pick. It's never good to throw a pick. It's never good to get sacked for 20 yards. So Brandon says, if you're using Reddit, then you're a fucking moron. Yes. Yep. But watching the screen caps of all those things are so hilarious. Yes, Reddit is a massive disease of shit. Yes, it is. Yes, it is. Destiny beats Kamala Harris. Oh. Let the reflow. Yes, very true. Oh, Chef Jameis's turnovers are delicious. Oh, stop it. Stop it. It's rough enough, chat. It's rough enough out there. So, and yes, X, I agree with you. This is equally applied to both sexes. Neither sex can use them for the purpose of gender identity disorders and gender confirmation. I think that's correct. It's only for truly diagnosed medical issues. And Mr. Alex is saying, just wanted to ask if we cover the Johnny Somali trial on December 20th. I believe it'll be on the 19th in the U.S. Is it going to be like televised? Because like the other thing is too, I hope there's like captions because like me no speak any Korean other than like I know what the word for you, the pronoun you means. That's the only Korean word I know at this point. So if Mindset's going to cover and he could translate or tell us what's going on, I'd be happy to be along with him. Or Jeff, like Legal Vices, or even Scott from Future Conflict. Maybe get Scott in here where I can have his kids and like family help me. But I have no idea. Like if they are talking in Korean, dude, we're fucked. We're fucked. So, but thank you for being here, Alex. I appreciate it, man. Blaze saying, Sean, I had my last midterm tonight. Your coverage of Nick was actually really helpful in Crim Pro. Thanks. Well, thank you. I appreciate like, you know, I like to say that I hope you guys learned something. If I really did help you, holy cow, thank you. Thank you. But at the end of the day, man, if you did the work, that's all you. So I do appreciate the compliment though. And I appreciate the thing. I appreciate that very, very much. But anyways, you know, I hope, congrats, you're done. Your midterms, although, I mean, don't you have finals coming up? Good luck on those, man. Good luck, and I hope you just banged it out of the park. Add AD for $2 saying the liberal judges are confusing sex and gender. Yeah. Yep. And remember, one of the judges was like, I can't tell you what a woman is. Maddie B says, is this a sitcom now? Okay, it does get funny, and like judges, like they're like, oh, is it my turn, your turn? Like it does get kind of, like when you're in those situations and you're in court, that does actually get funny when like there's a goofiness to that. So it can be funny at times. An American virus is freedom. Yes, it is. The American virus is freedom. So because some parents push this on their kids, some. A lot more than some, but I agree with you, man. I agree with you. Thank you for being here. Copy Kitty, thank you for being here. And guys, if I'm telling you, you know, thank you for being here, I really do appreciate it. You seem to be a name I haven't seen in a while, or your, you know, new name. And if I have missed you before, my apologies. But Copy Kitty saying, were all justices present and able to question, or is that not typical? Dumb question, I'm sure. No, all 9 justices were there. Now, usually it's not an issue if the judge wasn't available. Usually there might be times where the justices will have to recuse themselves from a case. So, for example, let's say there was a case where Clarence, well, not Clarence Thomas anymore, but Amy Coney Barrett, she was on the Court of Appeals when the case happened, or she was the district court judge where the case happened. Or let's say it's a criminal case from like a trial court in Nebraska, and Amy Coney Barrett was the prosecutor on it or the judge on it, like, just if they had any touching on the case at all, generally they will recuse themselves. And at that point, it turns into, well, you run with, you have 8 justices left. You need 5 votes to win. If it's 4-4, it's a tie, and it goes back down. And the prior ruling still stands. So generally, no. This one, they had all 9 there. And generally, for things like this, that's not a problem. But every once in a while, you run into issues where the justices can't be on a case because they already decided something, or there was a problem with it, or they have an interest in a case. But it's not too common anymore nowadays. Not too common anymore. And now we've got the crop of judges have been a couple of years. Like Judge Jackson was like what, 2022, 2021, I think. So she's got like almost 3 years of time in there. That means any case she probably would have touched, it's kind of like they're past that point of getting to her. So she's probably okay. Like, we're not going to see any more problems until we put a new judge on the Supreme Court, which very likely will happen with Alito and Clarence Thomas. They're old, and Thomas doesn't want to, he doesn't want to do this forever. I have a feeling those 2 guys are going to quit in the first 18 months. And then Trump will put 2 more on at the very least. And then Sotomayor, her health problems. Her diabetes is really bad, and it's caused a lot of health problems for her. Her health is not very good. So, she might kick the bucket or quit. And then, that's another judge. So, but I said, that's not a dumb question. And in chat, there is no such thing as a stupid question. If you're thinking it, someone else is probably thinking it at least. And I remember one of my teachers, my professors in college said that. He's like, look around this room. He's like, if you're thinking it, someone else is probably thinking it. And he says, and if they're not thinking it, I've probably thought about it. And it's not a dumb question. There's no such thing as a dumb question. I promise you. There's never a question I would laugh at you for. But thank you for asking it. Girat is saying, would your legal mindset ever consider going over the Stop Killing Games initiative, which deals with consumer rights issues? Love your content. Oh, hold on. Google this right now. Stop Games. Oh, I know what I've heard. Believe it or not, guys, Pirate Software, I found him doing YouTube shorts, and it's I really like listening to Thor. I like listening to him. He's great to listen to. But yeah, this is interesting. It's an idea that basically publishers can put a video game out, and it's on an online community, and then guess what they do? They shut down the servers and kill the game. So, yeah, and I know Louis Rossman is getting involved in that too. Yeah, I'd love to cover that. I kind of forgot that was a thing. But yeah, no, I definitely would to. I'll reach out to Mindset, see if we can do a thing on it. I think that'd be a lot of fun. Being a gamer myself and knowing many a gamer words. But thank you for the super chat, man. I appreciate it. Thank you for being here. Sneed World is a new member. Oh, yes, a worldwide sneeding. Thanks for the support, man. And then J-Rock with 10 subs helping to pray that gray away. Awesome. Awesome, chat. J-Rock, thank you for the support, man. I always appreciate it. You are a real one. You are an OG out there. So thank you. Thank you for the support. Then Blaze says, I'm at finals. Lol, I'm tired. Oh, that's okay. Hey, trust me. Dude, there were times where I would get done with finals and I'd feel super fired up, especially once I learned how to do them in law school. But yeah, after that, and here's the thing that's going to happen. You're going to panic. That's all, I'm going to tell you not to panic because that's what people would tell me. And I'm I still panicked. And then I got I get good grades and I'm I knew I did well, but you're going to panic. It's going to happen. You kicked ass, homie. I know you did. Spud Gun for £5 sterling. The King Sterling. And he says, hi, Sean, have some pennies. Wouldn't it be shillings, technically? Because I enjoy your stuff. We'll watch this cluster later. Is KBJ as retarded as the clips may imply? Yes, she is a moron. Amorone. Lamuse says for $5, Pirate Software is a total charlatan. Check out his farms thread. I didn't know. Everybody's got a farms thread. I'll have to look for him. I'll take a look at it. Thank you. Thank you, guys. Reminder, Heartbound isn't finished. Yeah, it seems like that's been taking forever, but I kind of get it. Alex says, just wanting to ask any chance he'll do a live stream with Legal Mindset. Yeah, I need to reach out to him because I know he's kind of like I know he's in Korea right now, but I don't know if he's going to be, diddy bumping all over Southeast Asia real quick or not. Like a bird flu. As long as he's chilling out, yeah, we'll reach out to him. Especially, we haven't had a chance to chop it up lately. We need to, as the kids say, chop it up. The King Sterling. It is the King Sterling. And Kelly Marie Appleby says the King Sterling £5 doesn't even get you fish and chips here in the UK anymore. That is horrible. The fish and chips is good. That's so sad. Kimbo says, did any of your attorneys in chat want to join Kimbo Law and fight for trans rights? I'm good. Polly says, Ross is the ferret Thorpe. It's okay. I guess I need to figure some things out about him. I guess I need to be learned, chat. I get learned. Will Reed says, KBJ is a pedo simp. Yes, she is. 100% she is. Nero says Sean pennies is a correct term as it is short for pence. Just got actionally, but that's good. And I learned something there. There we go. Sneedworld says, does that mean it's 5 British kilograms sterling? Yes, 5 kilograms. No, it's in the Internet Famous board. I will look for it. Felt Earth Cult says, no farms thread. Well. Oh. $5 used to be the cost of a po' boy. Not anymore. Yes. As there are no stupid questions in cereal soup, I mean, I think you kind of have to argue that. Because, like, you can have milk-based like soups and broths and milks, milk can be a foundation for a soup. So I think you could argue it's a cold soup. Yeah. I mean, it is weird when you argue it that way, but it is. I think you have to. J-Rock says, welcome to the Trump land, Kelly. Yes. And Kelly, thank you for being here. I appreciate it. Nice for you to be here. Welcome. Exa says, what the fuck is exactly a kilometer? It's like when you lay cocaine, it's when you lay drugs out and you measure how much drugs you have. You measure that by how long is the string of drugs you can make. Brooke says, can you pardon the Greys? No, I won't. You're banned. I can't pardon them. They can only be converted. Convert or die, Greys. You can't transition to becoming a green. Transing is what I say for the mods because I transition them into a mod. So Larry Legend says $5 won't get you 2 joints anymore. You sound like Willie Nelson in Half Baked. Like, I remember when a dime bag cost me a dime. It's like, well, that's what it's been. Spuggun says, Sean, a shilling is 5 new pence. The old British pound used to be 240 pence or 20 shillings. Because I mean, like, I know there's the song, like, here's, like, from watching Sharp, like, here's 40 shillings on the drum for those who volunteer to come. So, like, I know that. And they say, bugger the king shilling. Name a single milk-based soup. Do I look like Gordon Ramsay? No. I'm a consumer, not a producer. Like, I cook, but I'm like, I haven't watched that much MasterChef to know that, okay, J-Rock? Okay, I didn't go to Cordon Bleu. I eat Cordon Bleus, okay? A hot dog is a taco. I mean, yeah, technically, yeah. Poe says, how is this the world? Do they really just have to do that? Yeah, yeah. Yes, it's 2.2 pounds. Yes, 1 pound used to be equal to 1 pound of sterling silver. Yes. Yes. For the Emperor! Oh, wow, it's 1 o'clock, chat. We gotta land this plane here. Nero says, from the river to the sea shall the grays be free. No, 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 no. No. Not at all, no. Oh. It's like a kilometer's a communist mile. Squizgar for 10 subs. It's again, Grays. Keep moving, Grays. Keep moving. This is a green neighborhood, and it's sundown. So watch your back. Just wanting, Mr. Alex says, just wanting to recommend your viewers of a game called World of Warships. The game is fun. The Iowa and Montana battleships are in the game. Yes, they are. Yeah, they are. World of Warships is fun. But they don't pay me any money to talk about them. But yes, it's not a bad game. Not a bad game. Potato soup. Yeah, I think potato soup's got milk in it. Cream and mushroom soup. Yeah, there's cream soups. Yeah. Yeah, there we. Oh, here you go, J-Rock. Will breaks it off in your ass. But here's the problem: I don't eat clam chowder, so it's like, ugh. But yeah, potato leek soup, tomato soup, raw from crude, and milk or cream. Uh-oh, J-Rock. There you go. Yes, hashtag pray the gray away. Is a taco a hot dog? No, but we talked about this, guys. By the way, if you're new here, chat, every Thursday night at 9:30, we have a weekly show. We get to talk about all kinds of things that are going on. And we've got a lot to talk about for this week. A doctor in Dallas got in trouble for contaminating bags of IV solutions. Obviously, Hunter Biden got pardoned. The YSL trial is over. The main trial is finally over. There was the healthcare CEO assassinated. Daniel Penny is still in trial. The Hawk Tua girl, that spit on that thing girl, she might be in trouble for pump and dumping a crypto coin. And then Australia, their social media bill is still kind of up for debate. So we got some things to talk about for tomorrow. That's at 9:30 Eastern. A lot of fun. Hope you guys stop by. Hope you stop by. But we covered this on one of my shows, one of the Thursday nights. In Fort Wayne in Indiana, a judge ruled tacos are sandwiches. So it worked. Tacos are sandwiches. J-Rock says, a milk-based soup is unheard of and gross. You're gross. A hot dog is a taco and a corn dog is a pork Wellington. Yeah, you can make that argument. Nero says, I'm in YouTube comment jail. Yeah, I don't, and that's the thing, chat, if you're new, I don't ban comments. I don't ban people. I might time you out if you spam, but we run Somalia rules here. I'm sorry you're getting shut out. Yeah, the chat is still up. Chowder. Oh, God, chowder is so disgusting. It's Jill Stein's neighborhood. Oh, yeah, I bet you. World of Warships shill. I mean, heck, if Raid Shadow Legends came out here, chat, we'd be starting off. We're gonna talk about a murder that happened, but first from Raid Shadow Legends. I mean, I would shill them for they pay out, dude. They pay. I'll do it. No more free golden eagles from Sean. Oh. Don't tell 2.0 that, Sean. Well, I'm not going to dignify that with a response. AD says, what makes you such an Ohio State fan? I'm not an Ohio State fan. I fucking hate Ohio State. I'm a Michigan fan. I've always been a Michigan fan. Fuck Ohio State and fuck the city of Columbus. Fuck them all. The only thing Ohio State's got going for him is the band and when they play fucking Hang On Sloopy, because I love the fucking state of Ohio. I love our fucking rock song. That's right, chat. Ohio's got a fucking rock song as one of its songs. That's how awesome we are. And it's Hang On Sloopy, not Snoopy, just so we're clear. But yes, Hang On Sloopy is amazing. Eat clam cakes, the best fritters. I'm not, like I said, I'm not a clam or mussels guy. I don't like clams or mussels or oysters. I'm trying to imagine Sean selling Raid Shadow Legends to people. Well, we'll do it. Hashtag not guilty. Oh. Yes, most cream soups have milk to avoid using the actual cream. Yes. Is hot cocoa chocolate soup? I mean, kind of. Yes, PA. We'll mention that real quick. But like I said, I still think Ralph kind of got fucked over on that one. I still don't think that should have been done, but you know, that's what it is. Yeah, isn't it? Well, bechamels. Yeah, there you go. Boom. Boom. Larry Legends is, how did he get in trouble for a pump and dump when everybody knows it's a scam? I'm just saying, it does happen. That's a shame, says, well, that judge practiced with Judge Gull, so which judge? Oh, that judge practiced with Judge Gull. Okay, yeah, you're talking about the Fort Wayne thing. Hayden, Law, News, and Laughter with Aussie Overlord. Guys, Aussie Overlord. Give him a look. See what's going on with him. He's always got some good content. Ain't no debate about the social media ban. It's a fucking travesty. That's what I've heard as well. Because really, guys, when it comes down to the social media ban, they want to ban children from using it. There's only one way to do that. IDs. And then it destroys your online anonymity. So it's a method of control. Don't like it. Don't like it at all. But anyways, good to see you, Hayden. Hope you're doing well, man. And Spuggun says we have a MAID bill working through Westminster at the moment if you're interested. Yeah. Should be down below, potentiallycriminal@gmail.com. Fire that out to me. I'd take a look at it. That's pretty crazy. If you guys know what MAID is, that's the Canadian assisted suicide program. That's a shame, says practices, yes. There needs to be a mushroom compote for it to be a Wellington. Really? You're going to call it a mushroom compote? The Duxelle? The Duxelle is not a compote. I don't think you can call it that. I don't think you can call it that. Maryland crab soup. I would eat crab. Oh, Maryland blue crabs. Oh, my God. You go to Delaware, you on the coast, and you just get like a bucket of crabs. Like sometimes you can get up. Well, I don't know about now, but like many a summer, you get some all-you-can-eat crabs with a piece of nice ear of corn and some hush puppies. Hush puppies really weren't the best part, but eating crabs and having that corn, oh my God, it's amazing. Blue crabs are so good. It just sucks they're so little. So, Red Wings or Blue Jackets? Always Red Wings. Always Red Wings. I grew up with the Red Wings. So, the Blue Jackets, I don't really hate. I think it's a cool name. But other than that, I'll shill established titles next. I think that went down in flames, so I don't think you can do it anymore. Yeah, it's hard to argue with Sloopy. I know. A bad oyster can kill you. I've heard of that before. Yes, Columbus does have Schmidt Sausage House. I've had it. It's very good there. And yes, Stoney's has special cream soup that they serve. Aaron helps cook. Aaron helps make it when they do Naked Twister every Tuesday night when Aaron Imholt from the Steel Toe Morning Show is there emceeing it. Oh. The kids will start using a packet radio. Jim says, how glorious will the Spurgy be when Trump gets 3 more Supreme Court picks? I mean, when he gets 2, because he's going to get 2, he's in rarefied air. Not a lot of presidents have done 5 Supreme Court justices. He is going to be in rarefied air. Garrett says Giselle. True, I was grasping for that word. Yes. Crawdads? I don't like crawdads are a little different for me. I haven't done like a real crawfish boil, but like I grew up out here in Ohio. You'd run into crawfish and they're just fucking annoying. Like I never really thought to eat them. So Hold on, Red says you won my bet by being a Red Wings fan. Well, there you go. Better than my current hockey team's current name, the Utah Hockey Club. That's funny. Yes, the Blue Jackets have the cannon, yes. And Ron and Tony, how are you guys doing? From Obscure Destinations Outdoors, guys. If you haven't ever stopped by their channel. They do a lot of cool stuff over there with critters. Go to Blue Crab Festival on Saturday. Well, that sounds like fun. I would like that. And a Catfish Festival on Sunday, the last week of March every year in a town called Crescent City, Florida. Catfish Festival would sound like a lot of fun too. A lot of fried catfish. I could do that. Blackhawks do have the best jerseys. They have the old Blackhawks jerseys. I mean, they're one of the original 6 too. You can't. I mean, here's the thing. When it comes to the NHL, I have an affinity for the originals. Like the OGs have a spot in my heart. They all have they're just so unique and they have their own identity. It's so cool. I mean, like the Leafs, the Canadians, the Rangers, the Bruins, the Blackhawks, the Red Wings, like the originals. The OGs are so cool. In Michigan, we call them crayfish. Yeah, we do too. Yes, Red Wings has a totally different meaning in the Marine Corps. I am well aware of that. Don't worry. The Blackhawks do have great jerseys, but the originals, like the original guys, before they start messing with the jerseys, are good. Wings have the best sweaters. Dude, I'm serious. Like they're like, you get to like like not the current tarps that like the Leafs wear, but like they're like I like their uniform, the blue and the white, but also the Habs. You're gonna tell me you don't think the Habs have a cool setup? Their color scheme's good. They got a good drip. They make red and blue work really well. Yes, don't buy catfish in restaurants. Yes, I learned that a long time ago. Grifter Wannabe says the Maple Leafs are the Browns of the NHL. Oh, there's an entire book on that. A guy wrote, "Why do the Maple Leafs suck?" And at the time is because the Ontario Teachers Pension Fund was one of the like majority owners, and they were like geared towards just making money, not actually winning. Fuck Montreal. Oh no, come on now. So, did I get a text? No. Just my phone's weird. Like charges. Oh, it's 100%. There we go. Why no catfish at a restaurant? Because you're not getting catfish usually. You're getting like some sort of like whitefish. It's different though. Like here up in Lake Erie, because that's where I live out in Cleveland. Like and all along Lake Erie, like even like out west in Toledo and stuff, like perch fries and walleye. You can tell you're eating perch and walleye. They can't give you tilapia and like it give you the same thing. But like you can get some whitefish and you won't really know any better. I won't talk well about like the city of Toronto. Fuck that. Fuck that place. So, crackerfish. Yes. It's a crackerfish, chat. No crackerfish. All right, chat. So that is it for tonight. I think we're all caught up. We are all caught up. And you get some Pollock. Yeah, it could be that too. Yeah. Hold on, Squizzer, what did you say? Yeah, grouper is almost usually amberjack. Yes. That's another common one. You gotta go to good local, like if you're not on restaurants on the water, you're gonna get fucked on a lot of the fish because they're gonna trick you. Yeah, felt earth. Yeah, tilapia is too thin to larp as catfish. I know, but there's other white fish that can do it. And a lot of people who think they're eating catfish don't really know the difference and have never like caught a catfish, caught one, cleaned it, and then fried it up. They serve sawi as catfish. Okay, there you go. So as long as it's not rat, yes. Yeah, catfish has a distinct taste, but here's the problem. Like the people who really will know that don't go to like a restaurant in the middle of Nebraska and eat catfish. People don't know any better would eat catfish at a restaurant in Nebraska. Is it illegal to misrepresent the fish you serve? No. I mean, like, I would argue it is, but like they might not know any better. Yes, next thing I'll tell you a story about crab meat isn't real crab. Yeah. AD says, is Ohio a southern state? I'll end on this. So, like, here's kind of how I look at Ohio. And we're going to end this with a map. So here's how Google Maps. Here's how I look at the state of Ohio. All right. So hold on here. We're going to zoom out so you guys can't see where I live. So here is the state of Ohio. Here's the state of Ohio, chat. Right here. Right here. Here's the state of Ohio. Right there. Okay. And we got the little islands right there. Okay. So here's basically the state of Ohio. Like you've got like this part of Ohio and like here. Like that. And that's like God's country. From like basically, then you've got like here this is West Virginia, basically. And then over here, this is basically Kentucky. And then here is Columbus, and that's full of assholes. So that's kind of how I look at it. Alex says that's north of the Mason-Dixon line. Yeah, but still, you go to Southern Ohio, that's a world apart. I love Southern Ohio, and truly, I love every ounce of this fucking state. It is the best goddamn state in the union. Our flag would probably be banned in Britain because it's too pointy. In Australia, it's probably got too many points and it's sharp and dangerous. But I love this state. It is the best fucking state out there. So, I'm killing you. What do you think I'm going to say? Ohio sucks? Yes, Columbus is the state's asshole. Yes, it is. What makes it the best state? The people here. The people here in this state and with the history of this state and what it's been. It's been the frontier from the beginning. You know, the type of men that have come from this state. You know, astronauts, explorers, warriors. Like this state is a phenomenal state. It's got a little bit of everything. It's a good break. It's a good dissection of the country. You know, you got everything from the Rust Belt to, you know, Appalachia all rolled into one and everything in between. It's impressive in that regard. The geography of Ohio is amazing in that way. So, yeah. So that Wagner family mass murder was Southern Ohio. Oh, we are going to watch that. We are going to watch that pretrial hearing coming up here because it is fucking crazy. It is crazy. So that James says we have 3 astronauts from the county I practice in. Ooh, really? I didn't know that. Cool. All right, chat. But there you go. That's why Ohio is the best state around. And with that, thank you guys all for being here. Like I said, it looks like Tennessee's probably going to win this one. Probably 5-4 or 6 I'm probably 5-4. I'm betting it's 5-4. I see Roberts going over and being the fourth on the dissent. So, anyways, take care, everybody. And like I said, see you guys tomorrow night for the Thursday night show. And remember, until next time, just because you did it, doesn't mean you're guilty. Yeah. Just don't crash and burn in your oral arguments. That would be really embarrassing. Good night, chat.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy that Katie yelled at? Why, yes it was, he even knows he's fat. For all this fun and more, there's one place to go, here on Sean Martin's Potentially Criminal Show.
You win, Brewberries. You win for tonight. If only that's the way I could have done it. That should have been my sign off right there. Too bad it wasn't in time. But yes, just because you got your dick off doesn't mean you're a lady. Good night, chat.